Ms. Stetson.
May I have your attention, please? All rise. Lawrence County Municipal Court's now in session. Honorable Donald R. Capper presiding. All those having business before the court draw near and shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. Today is September 1st. I'm Judge Capper, and the way we do court here is we do reviews first. That's for people who have been in the court on probation and have orders to comply with. This is a check on those orders. So if you're here for that, your name's going to be called. Come up to the table with the group when your name's called. If you think you should have been called and weren't, go check with the clerk to the right when you leave the courtroom. And if you missed a hearing in the past, you're not going to get called today. You'll get called today, but you'll be called later in the docket, not with today's reviews.
Casey Barker, Candace Daniels, Joseph Edens, David Core, Joshua Ellis, William Gullett, and Christy Holland.
All right, Casey Barker is here. 21-6-14, 12, 29-16, 11, 349, 11, 849. Paying off your obligations. Do you have a payment today?
My bank has been messed up the last 2 weeks, but I'm going there as soon as I leave here to figure out what's going on with it. So if I can get it, yeah, I'll be making a payment today.
Okay, how much will you be paying?
$20.
All right. Everything going good with your work?
Yeah.
Which days are better with your work schedule for you?
Either way works.
Okay. October 6th. That's a Friday. 9 o'clock.
Thank you.
You're welcome. Candace Daniels,
Yes, sir.
it's case number 18795. All your community service is done, you've done some extra toward your funds. You still have somewhat of a balance, can you pay anything on it today?
I've got 3 more days of the community service you said you were gonna let me do. It's really hard for me to get a ride. But I'm gonna have that done by the end of this month. I was gonna talk to you about something else, but you don't look like you're in a mood this morning, so I'm just gonna let that
I
go.
don't. I feel fine. What do you want to talk about?
So listen, over this case that I'm doing the community service over, I had gotten arrested 2019, I think it was, or something like that. And whenever I got arrested, I had a warrant out in Ross County as well for driving under, it was a driving thing over in Ross County. And you told me, you released me on my own recognizance, and you told me to go take care of that in Ross County and to come back within a week. And then and I done that. Whenever I came back, you were like, okay, case dismissed. So I just it kind of confuses me, because whenever they arrested me back in April over this, he was telling me that it was over larceny, that I was being arrested over larceny, and I hadn't even been around here in 6 years.
Well, one, I don't remember saying such a thing, and two, the court speaks through its judgment entries, and I'm looking through your judgment entries, and I don't see anything like that in the judgment entries. So, sorry, but you must have misunderstood. You got a conviction on this, and you got to take care of it. It wasn't dismissed. So, you've got $170. Also, I want to tell you, from now on, I'm going to let everybody work off any of their fines or costs. The only thing they can't work off on community service is restitution, because that goes to another party. So you can work all this off by doing community service or pay, but you got to do one or the other. So
It'll be done this month.
all right. Now, I don't think you ever answered my question if you're going to pay anything on it today.
No, I don't have no money today.
Okay, so you're going to work off the rest of it. Okay, so 3.5 days will get it done. Okay, I'm going to set your next hearing for October the 10th. If you get it done by then, you don't have to come back.
Okay. Thank you.
You're welcome. Joseph Edens, I'm not sure how you pronounce it. Edens, Joseph. Hasn't done anything on his case, and hasn't appeared today.
Your Honor, I believe he's RRG.
Oh, okay, let me see the entry.
Yeah, he's in Glenville, Your Honor.
Okay. Well, and nobody's here from RRG, so let me text them and see, because usually they just give me a report as to how they're doing. Okay, so I'm going to put this aside. We'll recall it after I get a response from RRG as to what he's doing. Damon Core.
Yes, sir.
192634. And you've got a little bit left on your, the only thing you have left is fine and court costs, and you don't have that much left. Can you pay anything on it today?
No, sir, I can't.
How are you gonna take care of it?
Oh, I plan to get it taken care of monetarily.
You're gonna pay it?
Yes.
Okay, I'll set your next hearing for September 22nd, 9 o'clock. 9:22.
Okay.
Joshua Ellis,
This road.
08619. You have community service balance. You did quite a bit this last month.
Your Honor, he turned some in, he's done some dog pound also. So.
Okay.
Today, he turned it in today.
All right, are you making any payment on your funds today?
No, Your Honor, it'll be next Wednesday when I get paid.
Okay, you did quite a bit of community service, so we'll let that slide. Next hearing is October 2nd, 9 o'clock.
Thank you, sir.
You're welcome. William Gullett, 0972.
Thank you. Who?
It's kind of a mixed report. It looks like he hasn't done some of the things he was supposed to, but he has done quite a bit, it looks like.
Yes, Your Honor, I just got a call, he's running late.
Oh, okay. I'll put it aside and we'll recall it later in the docket then, William Gullett.
Thank you, Your Honor.
Thank you. Christy Holland, 19375. Not completed and has been called for, has not appeared, so she gets a warrant for not appearing.
Leroy Campbell, Bryce McMillan, Stephanie Romans, Melissa Weaver, Philip Bailey, Austin Hensley.
I'm here in order to.
All right, that was Melissa Weaver that spoke. So Leroy Campbell is here, 12/30/25, 12/22/59, and 10/6/27. Okay, it's a good report.
Thank you.
You look good. How you feel?
I feel all right. I'm a little tired. I have 2 jobs. It's kind of rough, but
How many hours a week are you putting in?
about 80.
That's a lot.
Yeah, I got a lot of bills.
I understand. It's that time of life, so you got kids to take care of too?
Yes, that's a big
Yeah.
part of it. I got a niece that I have to take care of, and
Yeah, well,
she's got a kid, and got a
it won't
car.
last forever. It seems like it will right now, but it's been, trust me, my kids are all grown now and all doing well. I don't have to support them anymore, but I was, at your age, I was right where you are. So it's not going to be for the rest of your life, but sometimes you got to work hard. And this is one of those times where you got to work hard.
Well, I'm moving right now. It's a little expensive right now because I'm trying to move and everything, and
Okay.
kind of I'm paying rent where I'm staying, and I'm trying to pay where I'm moving into too, so it's a little expensive right now, so.
All right, so I think that means you're not going to pay anything.
I know I made a payment.
Okay, you did. All
And
right.
I can make another one today. I get paid today, but I don't get paid till noon, so.
All right. Well, you're staying sober and clean, that's the main thing.
Yes,
So,
absolutely.
and on your work schedule, better for Mondays or Fridays?
It's whichever, doesn't really matter.
Okay, I'll make it October 13th,
Okay.
next hearing,
Thank you.
9 o'clock, October 13th.
Thank you, Your Honor.
You're welcome.
James Thompson?
Bryce McMillan has a new vehicle.
Yes, sir.
Got a report from New Life Recovery that you're doing what you need to do. You got a new vehicle, which I saw last Thursday. So this is 19,957, 19,944, and 19,114. Okay, you gonna pay anything on your fines today?
It'll be this afternoon.
Okay.
I get paid today.
How much?
20, 30 bucks. Finally, we'll have this car paid off this check, so.
I'll put you down for 20.
Okay.
Next hearing will be October 6th.
Thank you, Your Honor.
Thank
you, Your Honor.
You're welcome. Stephanie Romans,
Yeah,
long time no see.
right? Just got back on my hands.
I saw Stephanie last night. Is somebody, someone?
Yes, somebody, someone, yes. Or somebody.
Okay, it's a good report from Bethesda. It's good to see you last night, see that you're doing well.
Yes.
Case number 171080 and 173010. Okay. Can you pay anything on your phones?
No, I need to actually talk to Bethesda about doing community service for you, sir.
Okay,
We'll arrange that.
all right, very good. October 2nd will be your next hearing.
Thank you, Your Honor.
You're welcome.
Thank you.
Good job.
Thank you.
Melissa Weaver is appearing on teleconference. 16,490. 10,251. You just have fines to pay. You did your community service, and you have to make a monthly payment. Can you make a payment today? Melissa?
Yes, I can.
Online?
Yes,
How much are you gonna pay?
$20.
All right, I'll put you down for that, and your next hearing is October 2nd.
Okay, thank you.
You're welcome. Philip Bailey,
Yes, sir.
23,206. Looks like the only thing you've got left to do is the driver intervention program.
It's scheduled for September 21st.
Okay, I'll schedule your review hearing after that. October 13th, if you get a report in here, you're going to the one side of county?
Yes, sir.
Get a report in here that you successfully completed it, you don't have to come back.
All right, thanks.
9 o'clock, October 13th.
Appreciate it.
You're welcome. Austin Hensley, 23,117. Has not appeared, was called for, has not done anything on his case, so he gets a warrant.
Edward McCoy, Taylor Parmenter, Austin Wise, Brian Cooper, Kyle Federoff.
Edward McCoy,
Yes.
2328. You were at RRG, are you still there?
No, sir, I'm out.
Okay.
I'll be going to the NA meeting weekly, and keeping up with RRG, and I get the Vivitrol shot now instead of taking a Suboxone every day. I get the
Okay, I
shot.
want you to go, since I don't have a report from them, I want you to go do urine screening, and I'll have to come back after I get to urine screening.
Okay. What address is it?
Go with Mr. Cooper right here. Taylor Parmenter, 23189 and 191. And you're at RRG. Correct? Okay.
No,
You do have a report.
Regal Recovery Center.
RRC.
Yeah.
Lots of RRs.
There's 3 of them, so it's hard to keep them straight. Okay, it looks like we've had a little setback and we're making an adjustment, is that all right?
Yes, sir.
Okay. Can you pay anything on your fines today?
Yes, I will do it online.
And what, you've done some of your community service, are you gonna do, how are you gonna get that finished up?
I can on Wednesdays. I've already talked to him about it.
Okay. That'll work. I'll set your next hearing for October 6th. 9 o'clock. Austin Wise.
Thank you.
You're welcome. Austin Wise, 220858. It's called for,
He did not check it.
he's done everything but the driver intervention program. Don't have proof of that, so he's got 7 days to appear before warrant issues. Brian Cooper, 12/1976. Has done everything but community service and has 2 days left. Same thing, so he's got 7 days before warrant will issue. Kyle Federoff, 23/399. Fines are paid, you've got community service to do, what?
The community service, Your Honor, was completed through Miracle Connections. It's a nonprofit. Mr. Major told me that'd be fine. I gave the paperwork to Mr. Cooper.
That is correct, Your Honor. He has
Okay.
turned his community service in.
All right, so you got the 3-day school to do then?
Yes, sir. It's scheduled for September 22nd, 23rd, and 24th in Sauter County. I tried to get into the August class, but it was full.
I'll set your next hearing for October 13th. You get a report in saying you've completed that 3-day school and you don't have to come back.
I'm sorry, you said October 13th?
Yeah, October 13th. Should be plenty of time to get to the report in and file.
Yes, sir.
Any questions?
No, Your Honor.
Okay,
Thank you.
you're welcome. That finishes our reviews for today, so the next hearings are called the arraignment hearings. If you're here for that, that means it's your first time on a new charge or something happened on an old charge that caused a warrant to be issued. So anybody that's out in the lobby that's got a new case or called on a warrant needs to come in now. So when your name's called, come up to the table to your right, like the last people did, stand there. I'm going to tell you what the charges are, and if it's a misdemeanor, you'll be asked for a plea, which is your answer to the charge. You have 3 choices: guilty, not guilty, or no contest. The safest plea is always not guilty. That preserves the rights you have. The rights that defendants have in criminal court is to remain silent. You're not required to say anything, so you don't have to say anything, but if you do make statements, it's kind of at your risk, because if you get up and admit something about the case, that can be used against you. You have a right to have an attorney and to have one appointed to represent you if you're facing possible jail and you qualify financially. Depends on your family size and what your income level is as to whether I can appoint a lawyer for you. You have a right to have bail, and you have a right to make the state prove any charge beyond a reasonable doubt. If you enter a not guilty plea, you're preserving all those rights. You can always change it later to guilty. If you enter guilty or no contest, you're waiving those rights, and you should not do that if you don't understand the proceedings, if you want a trial, or you want to talk to a lawyer. You should enter a not guilty plea. Call the first case.
State of Ohio versus Tara Holzapfel, case number CRA 21651.
And you're Tara Holzapfel?
Yes, sir.
It appears that there's a warrant issued for you on June 3rd on a theft offense for failure to appear for that review hearing that was, actually the hearing was May 27th, the warrant didn't get issued until June 3rd, so a few days after that. Do you admit or deny you missed that hearing?
Yes, I missed it.
Do you have an explanation for missing?
Yes, sir. The doctor diagnosed me with lupus, fibromyalgia, gout, and all that. And I've been like in the bed. I've been really sick, congestive heart failure. Been in and out of the hospital.
Okay. Now, you were going to Mahajan and one of the orders was that you continue there and complete their services. Did you do that?
Yes, sir. She's supposed to be here, and they're supposed to fax you a letter yesterday.
Okay, I don't have anything. We'll just have a seat. We'll check and see if we can get a report from them.
Okay.
Recall.
State of Ohio versus Charles W. Brown, case number CRB 22413. Charles W. Brown. And I'll check in, Your Honor. Your Honor, I do know that he had called in earlier this morning. One said he couldn't be here because he got hurt at work, and he was told that he needed to get here unless he wanted the warrant issue,
Okay.
or unless he wanted the bond.
He has a bond up. He got arrested on August 30th. It looks like a posted bond. All right. Charles Brown has failed to appear. He had failed to appear previously, May the 5th, for a hearing. Then he got picked up on the warrant. It looks like this week, posted a bond on Wednesday, and then he's not here again today, September 1st. So bench warrant will issue, and I'm going to notify Mr. Sowers, the bail bondsman, that Charles Brown failed to appear today. And we'll set a bond forfeiture hearing for September the 18th. I think I've already set some for that date. For Mr. Sowers, warrant will issue today. Bond forfeiture September 18th.
State of Ohio versus Chase W. Rickman, case number CRB 23525, TRD 23650. Did not check in, Your Honor.
Charles Rickman. Are we sure he's not in the jail because he had a warrant from
He's here, Your Honor.
Okay. It's Chase Rickman, not Charles. Chase Rickman. Stand behind the table, sir. You should have been in the courtroom before. You would have known where to go. Are you Chase Rickman?
Yeah.
Mr. Rickman, it's alleged that on August the 29th, you not only caused Kelly Mintz to believe you would cause physical harm to her person or property. That's a menacing charge. It's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand that charge?
Yes, sir.
Yep. Then you've got an old charge, not that old, but earlier this summer, TRD 23650, which is a traffic charge alleging that May 31st at 5:04 p.m. in Union Township, you were driving a vehicle with a suspended license. That's a 1st-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. You understand that charge?
Yes, sir.
Do you understand your rights? Were you here when I explained the rights that defendants have?
Yes, sir.
You did hear that explanation of what rights defendants have?
Yeah.
How do you wish to plead to these charges? You can plead differently to the 2 different charges if you wish.
To Kelly Mintz, not guilty.
Okay?
She was supposed to come down, I think she's here today, and she's supposed to be dropping the charge.
Kelly Mintz, come into court. I don't see anybody standing up saying they're Kelly Mintz. So you want to enter a not guilty plea to that charge? Okay, is this Kelly? Okay, we don't have court outside on the sidewalk. It's in the courtroom.
I was with the victim.
Probably need the prosecutor to come in.
Yeah, I wrote a
Okay.
statement.
What's your connection with him?
Yeah, we have kids.
You all live together?
And then after the incident happened, he left, he'd already left. He was going home to get his stuff to leave. And we were cutting all these pizza. We rented it. And whenever he got to the house to get his stuff, apparently, the landlord had put a board in front of the door so he couldn't get his stuff and leave. Because he was going to his parents. And it was part of this issue that we had paid rent.
Is the court or the judge already asked if you wanted a protection order?
I don't think I do.
Okay, so here's what I'm going to do. I'm not just going to dismiss the charge. But we're going to have to come back and I want to make sure there aren't any problems. Sometimes,
Yeah, he's been
I'm
going
sure
to
you didn't.
therapy, and he's actually called the cops on us before.
Where does he go to?
Valley Health, maybe. something
Okay,
like that.
well, I'd like him to continue to do that.
Yeah, he's,
Okay.
even
What's he
before
go
this,
for?
even before this, he's been trying to get on medication. The other day,
The judge wants me to talk
he
about
got off of his medication.
Your Honor, and I've spoken with this young lady who's the alleged victim in this matter, and they are romantically involved, and she does not want a protection order. She says that Mr. Rickman already sees a therapist, and we'd like him to continue doing that. I believe it might be Valley Health. Valley Health?
Yeah.
So we'd like to see him do that, and we want to monitor this and make sure that there aren't problems that that can't be resolved through him going to counseling. So what we would ask to do is just find out for sure that that's where he's counseling at and come back in a few weeks and see where we stand.
All right, I'll enter a not guilty plea for you, Mr. Rickman. Do you want a lawyer appointed to represent you?
No.
No?
Yeah. Yeah, please.
Are you working?
Yes.
What do you do?
Just side jobs, just drag brush and stuff.
What are you making a week usually?
Just it's just $100 a day.
$100 a day?
Yeah,
Well, that's pretty good.
yeah.
How many, do you have any kids?
Yeah, I got a beautiful little girl with her, and I got her. I've had him for like 3.5 years. He's starting to call me dad. I'm just
You got one child that you're supporting or more than that?
basically two.
Two?
Yeah.
Okay, you're eligible for court-appointed lawyer then. I'll appoint Mr. Steyer. I'll let you sign a $1,000 signature bond, no kind, there'll be a no protection order at her request. So we'll need to set this fairly quickly. He also has, well, you didn't give me a plea on that, he also has a traffic matter of illegal driving under suspension from a different date.
A not guilty plea on that, Your Honor.
I'll appoint you on that as well, Mr. Steyer. And the bond will cover both. So I guess that probably helps us with our timeframes.
And this is an M4, so we either need a time
He has
waiver.
an M1 and driving under suspension too.
Oh, okay, all right.
Your Honor, I'm not available on the 11th or the 15th, but I'm available throughout the rest of September.
The 18th?
Sorry, I moved into October for some reason. Yes, I'm available that day.
September 18, pre-trial.
Okay, thank you.
You're welcome.
So just wait for me in the lobby, I'll be out there for the to talk to you. Thank you.
And it's my understanding he's doing some counseling, so
That's
it'd
what
be a
we
good
look.
idea if he continues with that.
Yes, but that, he goes, you have to find out where he goes.
I'm not sure. He has a doctor.
Okay. Thank you, Your Honor.
You're welcome. Okay, we're going to go to the jail as soon as they're ready to take us, but in the meantime, we're going to do some pre-trials.
State of Ohio versus James C. Jones, case number TRC 23536. Mr. Cremins' case.
James Jones. Mr. Cremins, pre-trial.
James Jones.
I'm here.
Your Honor, I spoke with Mr. Hill about this. There is a few things outstanding in discovery still after receiving the video that the state wouldn't have had any idea that would have needed to be provided at this time. He's going to get those to me. So if we could come back for another pretrial.
Okay. Is there still a problem with, because I thought we had some of that stuff worked out with emails or something on the video?
Yes, there's no problem there, Your Honor. I received the video, I've gone through the video, but based upon the video, there was some additional information I had to request from Mr. Hill.
Okay. All right, when do you want to come back?
I have September 29th, October 10th, and October 20th available.
29th is fine, is that the finished request?
Yes.
September 29th for a pre-trial, 10 o'clock.
State of Ohio versus Leah Maynard, case number TRC 23671, A and B.
It's Mr. Cremins' case, pre-trial.
Your Honor, again, I've received discovery in this matter. I've reviewed the video. I'd like an opportunity to go through it over the video with my client. We could also come back on the 29th.
September 29th, at the finished request, will be the next pre-trial, 10 o'clock.
State of Ohio versus William J. Wilburn, case number TRC 23-272, A, B, and C.
William Wilburn, Mr. Cremines case is a pretrial on a motion to suppress.
Yes, Your Honor. I filed the motion. Mr. Heel, we've talked about setting a date for that. I have September 29th, October 10th, or October 20th available for the suppression motion.
Well, there's a trial set on the 29th already. What was the other dates?
October 10th.
Did you just file that today?
It's not one in the file, I don't think. I don't see one.
It's filed, I don't have a copy of it.
It was filed today, Your Honor.
And one of the things I've done, Your Honor, is sent a message out to the trooper asking him what days he may not be available going forward for whatever reason, and that was just done here in the last half hour or so. Don't have an answer back from him.
Okay.
So,
I've indicated to Mr. Heald if there's a problem, once we set it, if there's a problem with the trooper, so long as it's not, shut the day of, even if it's the day before, that I wouldn't have any objection to moving it.
Okay, I'll set it at this point in October the 10th. That's a Tuesday, because Columbus Day is on the 9th. I'll set it at noon, October 10th.
Thank you, Your Honor.
State of Ohio versus Sean Woods, case number TRC 23-811, A and A through D.
Sean Woods is set for pretrial. It's Mr. Cremines' case.
Yes, Your Honor. Your Honor, if we could come back on September 29th for this, I expect we'd have discovery completed and could have a meeting for pretrial.
At defendant's request, the case is continued to September 29th for discovery purposes. 10 o'clock.
Thank you, Your Honor.
Okay, we're ready to go to the jail for some arraignments, I assume.
State of Ohio versus Mary Johnson at the Lawrence County Jail, case number CRB 23526, and Tad Johnson is on deck.
Is this on Mary Johnson?
Yes.
All right. Fix my screen. All right, so we have Mary Johnson at the Lawrence County Jail. Ms. Johnson, I'm Judge Capper. This is your arraignment hearing.
Hello.
Good morning. The purpose of this hearing is to make sure you understand the charge and to take a plea from you as to this charge. You have a right to remain silent. You don't have to say anything. If you choose to say something, it can be used against you. You have a right to have an attorney appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those rights?
Yes, sir. Yes, sir, I do.
The charge against you is domestic violence. It's alleged that on August the 31st of 2023 in Fayette Township, you knowingly caused or tried to cause physical harm to Christopher Love, and that Christopher is either a member of your family or a member of your household. So,
Both.
okay, that's what makes it domestic violence, that status of his. Maximum penalty for this is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes, I just want to go home with my former father. I just want to see my daughter.
Do you understand the rights that I explained that you have?
Yes, sir, I do.
How do you plead to this charge against you? You can plead guilty, not guilty, or no contest, and the safest plea is not guilty.
Not guilty.
Do you want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
I do not know.
Do you have any income coming in at all?
My fiance was the one that supported me and my 4-month-old daughter.
Is that Christopher?
Yes, sir.
Okay. I'm going to appoint a lawyer for you. I'll appoint Roger Smith to be your lawyer. He's here today in court. We'll get him in the courtroom and...
I'm here, Judge.
Oh, he is here in the courtroom.
Hi, in the
There's
court.
Mr. Smith. You can see him if you look on the image on the courtroom. You can see him standing behind counsel table.
I see.
All right, he's going to be your lawyer. I'm entering a not guilty plea for you. What's the state's position on bond and protection order?
Your Honor, we're not opposed to an OR bond. Under the circumstances, I would like for us to try to contact Mr. Lowe to find out his opinion about a protection order before we make a recommendation.
Is Christopher the father of this 4-month-old child?
Yes, he is the father of my 4-month-old daughter.
Okay. And is that where the child is with him now?
He lives with my mother and me at my mother's trailer, so they are all at my mother's trailer.
Okay. Well, I'm going to let the prosecutor contact Christopher and see what his position is on protection order. You still want to do that?
I do. They forgot to give us a phone number, so hopefully she has a phone number.
Do you have a phone number for Christopher or your mother?
I have a phone number for my mother. I can't remember his phone number because this is like a real weird number. It starts with 2s and stuff.
Okay, what's your mother's name, first of all?
Shannon Thomas.
And what's Shannon's phone number?
304-730-6534. I'm pretty sure that's it. I can't even remember my number off the top of my head.
Okay, oh, so lost art due to cell phones. Back in the day, as old people, we remembered all the phone numbers.
It's true.
Because we didn't have anything on our possession that remembered them for us, so you had to remember it. Okay, so I'm going to let the prosecutor call and see what their position is on bond, then we'll come back. Now, do you have a cell? Of course, everybody has a cell phone. What is your cell phone? It's for your lawyer.
Yes. For my lawyer?
Yes. Yeah, he wants
I'm
your
writing
phone
it
number.
down. Oh, okay. 740-550-1820.
Is it working?
Yes, it's at my mother's trailer.
Oh, okay. All right, we'll have you back after we get some more information. I'll decide what the terms of your bond will be after I get some input from the prosecutor on that. So, yes.
Yeah, I've never even been arrested in my life. I just want to go home with my daughter. I've never even gotten in trouble like this before.
I understand.
I never did anything.
Nobody wants to be in jail, so
No.
we'll have you back on. We'll call you back on this in a few minutes.
I just want to go to the doctor.
I understand, ma'am. You've told me 3 times.
State of Ohio versus Tad
I'm
Johnson. Case number CRB 16684. And Christian Larimore is on deck.
How you doing?
I'm doing great. This is your Tad Johnson?
Yes, sir.
All right, Mr. Johnson, it's alleged that you missed a hearing, a pretrial, actually. Mr. Steyer is your lawyer.
Yeah, real quick, I got a car.
Well, just hold on a minute. Hold on till we get your lawyer in the courtroom. You have a lawyer that's still representing you, so I want to get him in here before we proceed any further.
I heard my name, but I didn't hear what was called, Your Honor.
This is Tad Johnson, and it's been a while. You were appointed to represent him. He had a pretrial set for February 3rd of this year, and he did not appear. He had been in treatment. I think he left treatment as the allegation, and he got arrested on the warrant. So you are still his counsel. Probably should just let you talk with him before he He wanted to say a bunch of stuff, and I know you in particular don't like that. So.
Yeah.
So I advise you to remain silent until you talk to your lawyer, Mr. Johnson, and then we'll have you back out on the teleconference after that's happened.
If they could hold him out, I'll go ahead and call him.
You can have the court's file. I'm sure you don't have your file.
I don't have mine with me.
Okay, Mr. Johnson, we'll have you back after you talk to your lawyer.
Can the jailer?
Yeah, they can hear.
Clear spot, okay.
State of Ohio versus Christian Larimore, case number TRD 212259. Jonathan Nelson is on deck.
All right, sir, you're Christian Larimore. I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. It's alleged that you missed a sentencing hearing back in April 26th of 22, so it's been over a year ago, a year and a half ago. You were on a driving under suspension. You were supposed to be working on getting your license back and come back for a sentencing hearing in traffic court. You failed to appear, got a warrant issued, it looks like. Do you understand that allegation, sir?
Yes, sir. I'm still kind of working on that because I lost my social security card and I can't get a social security card without a ID, and I can't get an ID without a social security card.
Do you have an explanation for not coming to court in April of 22?
I thought it was for this month.
No, April 26, 22. Maybe you have new charges also? If you do, I don't have those.
No.
I'm just showing that you've got a warrant for not appearing back in April of 22. April 26, 2022. When did you get arrested?
Just a couple days ago.
You've been in jail a couple days?
Yeah, about 3 days.
You still living in South Point?
Yes, I'm working and I'm trying to get everything straightened out, and I just now started this new job. And I should be able to get everything straightened out and release a month or two at the most.
Well,
I should have everything.
I'm just going to go ahead and sentence you. I mean, it's been since August of 2021. You were delayed till April 22 to try to give you some time to get your license reinstated. That didn't happen, so you've already spent some time. You spent time in jail on a non-jailable offense. The reason you're in jail is because you didn't come to court. If you don't come to court.
Yeah, I totally forgot about that, sir. I was working and very sorry about that.
Me too, but you're not the only one this happens to, but you got to pay attention. If you don't want to go to jail, I wouldn't want to go to jail, so I would make sure I got to court when I was supposed to. So I'm sending you to time served and a $100 fine on the driving under suspension.
Okay.
And what I'm going to do on that, I'll just set it up as a final pay date of November 28th. So you've got the way this works, you've got the November 28th to pay your fine and court costs. And if you don't pay it, then we just send it into the BMV, and they're going to suspend you. You won't be able to get a license for whatever time they suspend you for not paying the fine and court costs. So it'll just dig the hole deeper if you don't pay it.
Yes.
But you're going to get out of jail today.
Okay, I appreciate that a lot, sir.
Yeah, we got other people there trying to get in there ahead of you, so I'm letting you out to free up a bit. November 28th, so just remember, you've got through the end of November to pay your fine and court costs. If you don't, you won't be able to get a license.
Okay, I'll write that down.
If you want a copy of the judgment entry, you can get it from probation. I'm not putting you on probation, but you can get it from them or the clerk. You can go on the court's website and look it up too if you don't remember. We have a website.
What can I do to get my social security card and I got a birth certificate.
Do you have access to a computer?
my phone, my cell phone.
Everybody's got a smartphone. If you go, the Social Security office has a really good website. If you go there, I'm sure it tells you what to do if you've lost your Social Security, how to apply for a new card if you lost it.
Okay. Okay, I appreciate that.
Yeah, just Google Social Security and it'll pop up.
Okay, I appreciate that a lot.
Okay, good luck.
Yep, you do, sir.
State of Ohio versus Jonathan Nelson, case number TRD 03-5140. April White was on that.
Sir, you're Jonathan Nelson.
Yes, sir.
Mr. Nelson, it's alleged you missed a review hearing August 21st, 2017. The court has a long memory. So if you don't show up, we issue a warrant, and it may take years for it to hit, but it looks like that's what happened to you. You got arrested on the warrant for failure to appear. So, do you understand the allegation?
Yes, sir.
Do you admit or deny you missed your hearing?
Yes, I missed.
Okay, do you have a good explanation for not coming? Not just an explanation, but a good one.
Yep, I just moved back to North Carolina. I just buried my mom and dad. And my wife's real sick. My wife's real sick. She's got stage 4 kidney disease.
Okay, well,
I'm taking care of it.
sorry to hear that. And it looks like this is the second time this has happened. Looking in your file, it looks like you got arrested once before for missing a hearing. So I'm going to finish it up with the jail time. When did you get arrested this time?
Could you please give me a chance to work it off?
I'm going to finish it by jail. How long you been in jail?
3 days, 4 days?
Okay, and you had some big jail time before, so you wound up, this is just like the last guy. You got jail on a non-jailable offense. You made a non-jailable offense jailable by not coming to court. So folks, they're out here watching. Learn something from, it's hard to learn from other people's mistakes, but if it was me, I'd be looking at this guy and say, I don't want to be that guy. I don't want to go to jail on a non-jailable offense. I'm going to come to court when I'm supposed to. That's an automatic get out of jail free card if you just show up. It's an automatic go to jail card if you don't show up. So I'm sentencing you to time served, completing your case by jail. You've probably spent 5 days in jail on a non-jailable offense already for not coming to court twice. Case completed. So you'll get out of jail today, and your case is over.
Thank you, sir.
You're welcome. Finally made somebody happy. You're welcome.
State of Ohio versus April D. White, case number CRB 2099. And we'll call more cases later, Taylor.
Okay. April White, is that you, man? You're April White?
Yes.
All right, so Mr. Morford, I don't know if she looks familiar, but it's been over 3 years, so probably not. From my record, it looks like you were the lawyer of record. She had a pretrial on May the 18th of 2020. She did not appear for, got a warrant, got arrested on the warrant, and this was on, she had been at Mended Reeds. She was discharged from Mended Reeds because she left against staff advice on April the 19th, 2020. And the charge was a domestic violence charge.
Did you say she was at Mended Reeds, Your Honor?
She was at Mended Reeds, looks like inpatient, and left against staff advice, and then didn't appear for a pretrial after that. So I'm going to let you talk to your lawyer, Mr. Morford. He will call and talk to you, and then we'll have you back after that's happened. So, Mr. Morford, here's the court's file. Don't lose it. Give it back to the clerk or me, and let us know when you're ready to bring her back out. So I think we're going away from the jail for a while. We'll be coming back for the folks we need to recall. Okay.
State of Ohio versus Tara Holtzapfel on a recall, case number CRA 21651.
Okay, this is one that we were looking for a report from Mahajan, and I didn't have one. From July 22nd. I'm reading the report.
Okay.
Okay, it says that you are you've been continuously engaged in treatment there for a while. So I'm going to close your case and say it is completed, because that's what you're ordered to do, is to stay in treatment and pay your fines, and you've done that. So your case is completed.
Thank you, Your Honor.
You're welcome. No warrant on that, should be withdrawn if it wasn't.
Okay, thank you.
State of Ohio versus John Riggs, case number CRB 23528. This is one right here.
This is an arraignment for John Riggs.
John Riggs? Yes, sir.
Sir, are you John Riggs?
Yes, sir.
Mr. Riggs, it's alleged that in Fayette Township, August 29th of this year, you tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft offense. Maximum penalty is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead to this charge?
Guilty.
Guilty means you're admitting it's true, and by doing that, you waive the right to have a trial, to have a lawyer, to make the state prove the charge beyond a reasonable doubt. Do you understand that?
Yes, sir.
Okay, I'm going to accept your guilty plea, and what I do on all, we get a lot of shoplifting cases because the Walmart's in my jurisdiction. And I always order people to do urine screens because a very high percentage of people that are shoplifting have a substance use problem. So, go do a urine screen, come back, I'll sentence you after I get the results.
State of Ohio versus Darrell L. Runyon, case number CRB 23529.
Okay. I think there's if you look in the body of the complaint, we got the name wrong.
Yes, Your Honor, it is Runyon, and we'll move to amend that.
All right, I'll strike out Robinson and replace it with Runyon. The caption is correct, but in the body is correct, or incorrect. All right, sir, are you Darrell L. Runyon?
Yes.
Mr. Runyon, the state's filed a complaint against you alleging that on August 28th of this year, by threat of force, you caused Tammy Runyon, who's a member of your family or a member of your household, to believe you would cause imminent physical harm to her or a member of her family or household. So that's a domestic violence charge. It's a 4th-degree misdemeanor. The maximum penalty for it is 30 days in jail and a $250 fine. Do you understand this charge, sir?
Yes.
Do you understand the rights you have as a defendant?
Yes.
How do you plead to this charge?
Well, I'm gonna put not guilty, but
Do you
she's
want
supposed to drop it anyways.
Is she here today?
Yes.
Tammy Runyon? Tammy Runyon, come into court. Okay, she is in here. Come up and talk to the prosecutor, please.
Your Honor, I've spoken with Ms. Tammy around here. You'll need to talk to the judge a little bit too. She doesn't want a protection order. In fact, she wants the charges dismissed. However, the allegations are kind of serious, and so we're not ready to dismiss the charges, and we want to find out that there's not going to be further problems. And it's our belief that Mr. Runyon could benefit from some anger management counseling. So if he's willing to do that, we would be willing to extend the case out and make a decision later on as to whether we felt we needed to go through with the conviction.
Okay, Mr. Runyon, do you want to be considered for a court-appointed lawyer?
So we got a baby today, and I'm helping her with a house, so she did have a house for my baby.
Okay,
Where's that a misunderstanding? There wasn't no argument at all.
I don't think that's what I asked you. You didn't answer my question. My question is, do you want to be considered for a court-appointed lawyer?
Yes.
Do you have a job?
No.
You have no income?
No.
I'll appoint Mr. Morford to represent you. So we'll get Mr. Morford in the courtroom. Not guilty plea is entered for you. And no protection orders required. You don't want him ordered to stay away from you? All right, we need Mr. Morford, please, in the courtroom. There he is. This is Darrell Runyon. It's a 4th-degree misdemeanor domestic violence charge. I'm appointing you to represent him.
Thank you, Judge.
And no protection orders requested. So unless there's a time waiver, we'll need to come back fairly quickly.
Judge, if there's no contact order requested, not a contact order requested, and he's out on OR bond, we will waive time and put it at the court's convenience.
All right, he can sign, well, he already has a bond up, so I'll just continue that bond.
Okay.
So he will be out on bond. So I assume that still applies, your time waiver, since he's out?
Yes, Your Honor.
So let's look for a date. And then you're gone a week in September sometime, Mr. Hill, which?
Just the 15th and the 18th.
Okay, so the 22nd's a good date. I'll set the 22nd of September as the pretrial date.
Here then, Judge.
Pretrial at 10 o'clock. Anything else?
Well, Your Honor, we did suggest that anger management counseling might help this along as far as the state's concerned. So if Mr. Morford wants to speak with Mr. Runyon about doing that and come back with a report that he's starting to take part in the counseling, we would.
Well, and I'd also ask, I mean, I don't want to read too much into it, but look at the affidavit. It looked like there may be substance use issues also, so that may be something to take a look at.
Ms. Ryan,
might ask her.
Yes, she didn't indicate that there. She indicated that there wasn't, but you know, we would still like to at least have that looked at.
Okay.
No.
All right. Next hearing is September 22nd. Which has all
State of Ohio versus Corey A. Cordell, case number TRC 23906 ABNC.
This is a pretrial for Mr. Smith.
Judge, this is a
urine test. Do we have the results back?
Urine test, the results are not back now.
He'll have you go to school probably. He'll have you to jail. School. 3 days school of enforcement.
When's our time frame?
Time to set it up.
October 1st. There's been no discovery filed, so.
It's not been filed, Judge, because I'm waiting for test results, but my client has just spoken to me. He would like me to go ahead, because there's no contest put on his behalf at this time, even though you understand I don't have discovery back test results.
I don't want to keep wasting everybody's time.
It's his choice, Your Honor. He would enter a no contest plea.
All right, and now, I want to make sure you understand, Mr.
Yeah.
Portal, you submitted to a urine screen that went to a lab in Columbus for testing, and we don't have the results yet, so I don't know what it's going to show. You probably have an idea what it's going to show.
I do.
But I don't.
I do.
So you have a right to wait and see those results if you want.
I'm fine. I just like to go ahead and move forward.
Judge, then we would enter that no contest plea, stipulation of facts sufficient to find my client guilty.
All right, and you agree with that, Mr. Porter?
Yes, sir.
Is there any statement you want to make before I sentence you?
No.
Okay.
Your Honor, it says he did not have insurance at the time.
Did you have insurance on your vehicle?
Did you
Yes,
have
I
the day
do.
of the arrest on
You got that with you today?
July 3rd? Did you have it?
Can I run out to the car and get it?
Yes, and then while you're doing that, I also want you to do, I don't have the results from the urine screen you did on July 3rd, but I want one today. If you're going to plead guilty, or no contest, and I find you guilty, I want to know what's in your system. So I'm going to have you do a urine screen here.
Just recall this one, Judge.
Or recall it, go get your insurance card, and go take a urine screen, and you go to the probation office to do that to the lab.
That's
Do a urine screen.
Grab your card and get that test done. All right.
State of Ohio versus Shelby N. Rodriguez, case number TRC 23-816, A, B, and C.
This is Mr. Smith's case, and it's set as a pretrial.
Okay, there you go. Judge, same situation. I'm informed we do not have the test results back on Mr. Rodriguez, and he is going to take my advice and ask this matter be set out a little bit so we can get those test results.
What's the time frame?
9/28.
Okay.
I'm here the 15th, 18th, or 22nd, Judge.
And it's the 15th and 18th when you're not here.
That's correct. But that's.
It doesn't matter.
Right, even that one it doesn't. Sure.
18th then?
He wants to do the 22nd for his schedule.
Well, that doesn't give us much time to get a trial scheduled. What date were you?
Oh, that's what I meant to say. September. Okay, 18th will work, Judge. He's telling me. We can make that work.
September 18th?
Yes.
Will be the next hearing for a pretrial at 10 o'clock.
Let you know if I get results. Take that read that's a synopsis of what happened. I'm here looking for the video she watched. That's yours today. Just read it. I'll let you know if I get the results. Appreciate it.
State of Ohio versus Ethan R. Anderson, case number CRB 2319.
Your Honor, Mr. Anderson, I guess, has a warrant out of common pleas court, so.
He's decided not to appear today, too.
Well.
And he was with QRT.
Yeah, they terminated QRT, I think, last time.
And they brought him back, well, the intention was for him to go back before common police court this past day before yesterday.
And he didn't appear.
And it didn't appear.
Okay, we'll get a warrant from here, too.
Your Honor, I know on 8/25, you gave him a signature bond, but he had a holder from common pleas. They must have lifted that holder at some point, so.
Yeah. I see an OR bond in the, well, that's the one I issued.
Yeah, there was no OR bond from you, but you issued that because he had a holder.
Right.
And I don't know what happened with the holder. He didn't.
Well, I think, I'm just guessing that they got my OR bond, felt that he was good to go because the release time's the same time that my OR bond hit. So I'd say there was a mistake made there. Mistakes happen.
Yes.
So that's one, we have to really be careful when we send it down to the jail. We're releasing only our holder, not the common pleas holder. It's right on top.
State of Ohio versus Fiona R. Benson, case number CRB 23472.
Your Honor, the state has presented an offer this morning. This is our first pretrial on this matter. Would like to set up for another pretrial so I can go over that offer with her and go over the discovery with her. Over here.
Yeah, the preference is to the date to come back.
A couple weeks, Your Honor, be fine.
Okay, that's the 15th. Mr. Heald's not going to be here, but I guess somebody will be trying to fill your shoes.
And I make notes to help it make it be easier for them.
All right, September 15th.
September 15th. Thank you, Your Honor.
You're welcome.
State of Ohio versus Victoria Stinson, case number TRC 231056A and B.
Your Honor, this is first pretrial in this matter, OVI, failure to control. Would like to just get the video from the prosecutor, review the video before we make a decision on the offer. So if we could set this out a little bit further to make sure we get that. I know sometimes it's not quickly.
Have you filed discovery?
Yes, I did.
Today?
Yes.
22nd, 3 weeks.
22nd is fine now.
September 22nd will be the next hearing, 10 o'clock.
State of Ohio versus Alec R. Berry, case number TRC 23957A and B, and TRD 23292A and B.
He is there. Okay.
Well, that's good. I'm glad he's here.
Hey, how's it going? Does this have a completion? How much longer do you think he's going to be in services?
Okay, it's a good report.
60 days. Okay.
And he's done quite a bit of community service in the last month, so that's good, on his old case.
On the old case, yeah, which was set for review today. Your Honor, the prosecutor has mentioned that he would like a plea today or set up for trial. I think we should just set it for trial, but we can do that.
Well, is there a jury to meet?
There is. There's always every time. Your Honor, we could set up for a final pretrial. We'll probably take care of the matter at that time. Let's do this one.
We're okay with the pretrial, and if he wants discovery, we'd be happy to, I don't think he filed a discovery demand, we'd be happy to comply with that.
Just 1 second, Your Honor. If we plead, he will just set up some, I believe we would just continue to set up some.
Well, that's fine.
Okay. Maybe what the sentence today says, suspended time. He considers this a normal. So, we take it, He will be. Your Honor, we're going to go ahead and plead guilty today to the charge. I think it was. Mark Lanes. And guilty to the OVI and to the Mark Lanes, Your Honor. Just ask that sentencing be put off until he's going to be in the program for another 60 days, so.
Okay. That's fine. So he's pleading guilty today?
Yes, we'll plead guilty today.
Is that correct, Mr. Beard?
Yes, sir.
All right, I'll accept your guilty plea, but I'm going to delay the sentencing and let you continue in your treatment, finish that up. So let's come back in about a month and see where we are.
Yes.
1st of October sometime. What's your schedule in October?
It's fine, Your Honor. Let's have a trial that doesn't get settled.
October 13th?
Yes.
Okay, that'll be a sentencing then. October 13th for sentencing on 23-957 and a review on 23-915.
Yes.
Okay, and both will be set at 10.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jerry L. Cheney Jr., case number CRB 23493.
This is Mr. Steyer's case, set for pretrial.
Who are these people? Okay. Well, hang on just a second. Let me talk to the prosecutor. Any further information from your alleged victims? He's getting stuff on to update discovery.
Okay.
You want to come back one more time and then?
Yeah.
Your Honor, Mr. Cheney just provided me with some documentation that I'm going to need to go through and determine whether it needs to be provided as an update to discovery as well. I think there's a couple of issues that Mr. Heald is still addressing involving in the case. So I think it might be worthwhile to do one more pre-trial prior to a decision on whether we want to try this case. So at this time, I just have to ask for another pre-trial. We'll waive time constraints to accommodate that.
Do you have a preference as to a date?
25th.
Is that agreeable to the state?
Yes, Your Honor.
All right. September 25th will be the next pretrial at 10 a.m. And Mr. Cheney, I appreciate the time.
Thank you, sir.
And I need you to sign right here. All right, that was your phone number. You can write it down for me.
Okay, we're going back to the jail to finish up some of the hearings there.
State of Ohio versus Derek Blankenship, case number CRB 22701 at the Lawrence County Jail, and Kevin Dale is on deck. Derek Blankenship.
Sir, are you Derek Blankenship? Can you hear hear me, Mr. Blankenship?
Yes, sir.
Okay. I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake, where your hearing is taking place and you're appearing in the court on a monitor. Everything's obviously being done by teleconferencing. So it's all being recorded. Your image and what you say is going down on the record. You have a right to remain silent. You don't have to say anything. But if you do make statements, it can be used against you if you admit something that's against your interest. You have a right to have an attorney, to have one appointed, a right to bail, and to make the state prove any charge beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
So I'm going to go over the charge with you now. It's an older charge from last fall, October 26, 2022, Fayette Township. It's alleged you knowingly caused or tried to cause physical harm to Amber Hankins, and that Amber is either a member of your family or a member of your household. That's a domestic violence charge. It carries a maximum penalty of 6 months in jail and a $1,000 fine. Do you understand this charge?
Yes, sir.
How do you wish to plead to the charge?
Not guilty. She's supposed to already came in and wrote a statement saying it wasn't true the very next day. And then she's been back again to explain that she was pregnant and what was going on or whatever. I wasn't even around her. I was in Galveston, so I'm pleading not guilty.
Okay, Mr. Field, I don't make the charging decisions, Mr. Blankenship, so I'll ask the prosecutor, does the state still want to go forward with the charge?
The allegations, if they were true, are very serious, number one. And we did, number two, get a letter from Ms. Hankins. She signed a statement on October 31st saying that it was all a big mistake. So I don't know if she's here or not. Is Amber Hankins here?
Amber Hankins, come into court. You're here. Yes.
I think she's at she's with Chris Delaware. That's my lawyer, so.
Well, neither one of them are here. I know what Chris Delaware looks like, and I don't see him anywhere.
Yeah, because we thought he'd dismissed.
Well, this is from October of 2022. Oh, yeah, so this is only the beginning of September. Yeah, this is old.
Right.
However, serious allegations, I don't know what's happened between then and
Okay,
now.
well, the state's not willing to dismiss it at this point, and there's nobody here pleading for it to be dismissed. So we're going to go forward with it, Mr. Blankenship, and I'll enter a not guilty plea for you. Is Mr. Delaware going to be your lawyer?
Yes, sir.
Okay, I'll put him down as your lawyer. What's the state's position on bond for Mr. Blankenship?
We're not opposed, well, I'd like to know when he got served and why it's taking so long to get him.
I was arrested in Kentucky.
Have you got something in common police court then too?
Yeah.
Okay.
Yeah.
And you haven't appeared in common pleas yet then?
No, I'm here Wednesday.
And he has a hearing next Wednesday, but I don't know, do you know what the charge is?
Do you have a lawyer? Will Mr. Delaware be representing you in common pleas also?
Chris is representing you on all of it.
Okay. Well, do you still want to do the OR? And we need to make sure the jail knows this is an OR bond only for the charges here, not for the felony charges.
They're not going to let me out anyway.
What we'd like to do, Your Honor.
You never know. Sometimes they mess up.
If I could have a few minutes to figure out what he's being held on in common pleas court and what we're doing.
Okay, the prosecutor wants to investigate this a little further before we set bond, so I'm going to let him do that, and I'll have you back on the monitor after they've done some research.
Okay, that's fine. Thank you.
State of Law versus Kevin V. Dale, case number CRB 23527, CRB 20859, and Justin Holland is on deck.
Okay, I've got some new charges and some old charges. And are you Kevin V. Dale?
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court, which is located in Chesapeake. This is where your charges are currently filed, and this hearing is happening in the court by teleconference. So your image is in the courtroom on a big screen that everybody can see, and it's all being recorded. What you say and your image is all going down on the record. So, as a part of your rights, you don't have to say anything, but if you do make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove the charges beyond a reasonable doubt. You understand those rights?
Yes, sir.
Okay, let's start with the newest charges first. It's a domestic violence charge. It alleges that on August the 28th of this year, in Perry Township, you knowingly caused or tried to cause physical harm to Paul Brackett, who's either a member of your family or a member of your household. So that's a domestic violence charge. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand that charge?
Yes, sir.
Then there's an old charge from 2020. And it's a criminal damaging complaint. 2859 is the case number on that. It alleges that on October the 8th of 2020 in Perry Township, you caused risk of physical harm to property of Larry McKnight without his consent. So that's criminal damaging. It's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand that charge? It had to do with a camper. Damage to a camper is what the charge says.
I assume that was dropped, Your Honor.
Well, for some reason, it never got brought before the court till today. I don't know if there's been a warrant outstanding since then. Looks like there was an attempt to serve you, and the return says that it was the wrong address back in 2020. How do you plead? And you can plead differently to these two different charges. So let's start with the oldest one first. How do you plead to the criminal damaging charge?
Guilty.
How do you plead the domestic violence charge, which is 2023?
Not guilty, Your Honor.
You want a lawyer appointed to represent you?
I'm not able to afford a lawyer.
You're not working?
I mean, at the time, I had a job before I came here, but I lost it by now.
What were you doing?
I was doing Christian home care.
Were you paid by the hour?
Yes, sir.
How much per hour?
$14 an hour.
How many hours a week?
35 to 40 hours a week.
Do you have children?
No, sir.
Is this seasonal work? You only work during grass cutting season?
Yes, sir.
Okay, you're going to be eligible for a court-appointed lawyer anyway then. So I'll appoint Mr. Stratton to represent you. Mr. Stratton, this is Kevin Dale.
Yes.
He has two charges, a current domestic violence charge and an old criminal damaging charge. He ostensibly entered a guilty plea to the old criminal damaging that was uncounseled, of course. If you want to withdraw that, you can. I'm going to appoint you to represent him on both matters.
Yes, sir. We'll withdraw that guilty plea.
I'll enter a not guilty plea as to both. State's position on bond for Mr. Dale.
Your Honor, we are going to request a protection order first, and then I guess we want to know if Mr. Dale has any reason why he has to be around his father at this time. His father's Paul Brackett.
Okay. Can you stay away from your father, Paul Brackett, while this case is pending, at least for a while? You don't live together? You have a separate place to stay other than with him, is that correct?
Correct.
Okay, so just that there's no allegations that something happens, I'm going to order that you not go around him Don't call him, don't contact him, don't post things about him. I want things to calm down while we're in court. I don't want there to be alleged another incident to have happened.
Yeah, we'll sign a protection order.
So to do that, I'm ordering a protection order, which means you're not to go within 500 feet of him.
Yes, we'll sign that protection order, Your Honor.
That'll be sent down to the jail.
Okay.
I'll let you out on an OR bond of $1,500. So as long as you come to court when you're ordered to, you don't have to post $1,500. If you decide not to show up, you'll get a warrant, and then you'll have to pay $1,500 for not showing up, besides you go back to jail. So just come to court when you're ordered to, and we're going to decide when that's going to be.
Then the next couple of weeks, Your Honor?
15th?
Yes. And Mr. Dale, do you have a phone number?
Yes, sir.
What's your phone number?
1-740-307-2544.
September 15th, correct, Your Honor?
September 15th at 10 a.m. Do you know where the court is in Chesapeake, sir?
Yes, sir.
Okay, that's where you have to be. You're going to get out of jail today. Can't go around your dad. Go back to work, though. And we'll see you on the 15th at 10 o'clock.
All right, thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Justin Holland, case number CRB 23530. Taft Maynard is on deck.
Sir, are you Justin Holland? Yes. I'm Judge Capper at the Lawrence County Municipal Court. Mr. Holland, I'm going to go over the charges that you have here in a minute. First, I have to explain your rights to you. You have a right to remain silent. You don't have to make statements, but if you do, it's all going on the record. Everything, your image and what you say is all being recorded, so if you admit something about the case, the prosecutor could use it against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things? Yes. The charge is theft. It's alleged that on August the 28th in Fayette Township, you tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft charge. Maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge? How do you wish to plead to it? Guilty means you're admitting it's true. Okay, I'll accept your guilty plea. I'm going to order that you submit to a urine screen there at the jail. So I'll get those results, and after I do, then I'll sentence you. So the jailer, if you could do a urine screen and let Mr. Major know what the results are, and then I'll let Mr. Cooper know what the results are, and then I'll have him back for sentencing after that. Go do your urine screen.
State of Ohio versus Taft D. Maynard, case number CRA 23531, CRB 23538. Jameson Watts is on deck.
Sir, are you Taft Maynard? I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake, where your case is filed. You are appearing in the court by television monitor. You're on a screen in the courtroom. It's all being recorded. So if you say something against your interest that the state wants to use against you, they can. You don't have to say anything. You can remain silent. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove the charge beyond a reasonable doubt. Do you understand those charges or those rights you have? Yes, sir. You've got two charges. Having a weapon while under disability and domestic violence. Those are the two charges. The 23531 is the weapons charge. It alleges that on August the 28th of 2023, in Fayette Township, not being relieved from the disability to have a weapon or use a firearm, that you were under indictment or had been convicted of a felony offense of violence, so that disqualified you from having a weapon, and that's the charging issue is having a weapon while under disability. It's a felony of the 3rd degree. Maximum penalty is 5 years in jail, $8,000 fine. Then 23-533 is a domestic violence complaint. It alleges August 28th, you knowingly caused or tried to cause physical harm to Donnella Brown, who's either a member of your family or a member of your household. That's a 1st degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand these charges?
Yes, sir.
Do you understand your rights?
Yes, sir.
Do you have the money to hire a lawyer?
No, sir.
Are you working?
I was working, but I haven't worked for the past week, and I have, due to being incarcerated. I have no money right now. One of Danelle Brown's daughters actually trying to get money up together for my bond because Danelle Brown's not even pressing the domestic violence. She ain't even in state no more. She's in Tennessee right now, sir.
Okay. What's the state's position on bond for Mr. Maynard?
Your Honor, there's an allegation that he had possession of 2 firearms during this, so it's just on its face, it's concerning. Is Danella Brown here, or anybody in the family? We asked for a $5,000 cash and surety bond, and we're going to ask for a protection order.
Okay, let's get him a lawyer too. I'll appoint Mr. Steyer to represent Mr. Maynard. All right, I'm appointing you a lawyer, Mr. Maynard. It's Mr. Steyer. He's here in the courtroom. He's been listening to what's going on. I'll set the bond the state's requested, $5,000 cash or surety. Is that a bond you think you can post?
Is it 10% to the bail bond, or is it?
It'd be roughly 10% to the bail bondsman. The bondsman has to decide what they will take, but it's usually about 10%.
Yes, sir. I can post that today, sir.
All right, so you want a bail bondsman to contact you there at the jail?
Yeah, could they contact my fiance, Bethany Smith?
Okay,
Yes.
so that's Danella Brown's her mother?
Yes, sir.
Okay.
She's my fiance. I've been with her for 11.5 years.
What's her name? All right,
Bethany Marie Smith.
Bethany Smith.
Bethany Smith, what's her phone number?
1740.
Just a second, I gotta put this in my phone.
Bethany Smith.
Okay, I've got 740
442
442
1559.
Okay, I've got that number. I will give that to the bail bondsman that commonly works in this court and have him contact her.
All right, thank you so much. My daughter's been waiting to see me. We have a daughter. I know when, sorry, go ahead, sir.
When do you want to come back for the next hearing?
Again, I'm available all upcoming court dates except the 11th and the 15th throughout September.
Well, are you waiving time then?
Are you confident you can get out? You'll be able to get out of jail?
Yes.
Because if that's the case, then I can waive time constraints and we'll go out a little bit longer. But if you don't get out of jail, you'll just be sitting there for all that time.
Yes, you just have to contact Bethany Smith and let her get in contact with the bail bond. She has all of our money.
I'll get it taken care of.
All right.
Then yes, we'll waive time constraints. So,
How about let me check that date. I'm looking at is it the 11th the day you're not?
the 11th and 15th is the week I'm not here.
Okay. The 18th?
I'm available that day, Your Honor.
All right, Mr. Maynard, I'm saying your hearing for September the 18th at the court in Chesapeake at 10 o'clock. You have to be here then.
Yes, sir.
Any questions, sir?
No, sir.
Is there a protection order then on requested?
Yes, Your Honor.
And you say it's not a problem because you went to Tennessee, but I'm warning you stay away from Danella Brown while this case is pending.
Yes, sir.
So there'll be a protection order sent down for you to sign at the jail.
Thank you.
Yes, sir.
State of Ohio versus Jameson Watts, case number CRB 23532A and B, Mary Johnson.
All right, sir, are you Jameson Watts?
Yes, sir.
Mr. Watts, I'm Judge Capper at the Lawrence County Municipal Court. This is your arraignment hearing. I'm going to go over the charges. You have 2, theft and criminal trespass. You have a right to remain silent. You don't have to say anything. If you choose to make statements, though, they're on the record and they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove any charge against you has to be proven beyond a reasonable doubt. Do you understand those things? On the theft offense, it's alleged August 28th of this year in Fayette Township, you tried to deprive Walmart of property without their consent. Maximum penalty for that, 6 months in jail, $1,000 fine. 532B is a trespassing charge. It's alleged that you didn't have the right to go in Walmart and therefore you were trespassing. That's a 4th degree misdemeanor, maximum penalty 30 days in jail, $250 fine. So that usually means they're alleging that you've been previously convicted of some sort of theft offense. Do you understand these charges, sir?
Yes, sir.
How do you wish to plead to these charges? Guilty, not guilty, or no contest? Those are your choices. No contest means you don't want to fight the charge. You're agreeing you can be found guilty without a trial and a lawyer representing you. If I look at what evidence the state says it has against you and say that at least meets the legal standard for conviction. So it's going to result in a guilty finding most of the time. So is that what you want to do?
I guess, sir.
Well, you got to be sure. If you're not sure, you should enter a not guilty plea.
Not guilty.
Do you want to be considered for a court-appointed lawyer?
Yes, sir.
Do you have a job?
Not like I was Social Security.
I'll appoint Mr. Morford to represent you. He's here and has been in the courtroom the whole time, so he's listened to what's happening. What's the state's position on bond? He has a Huntington address. Is it, you live at Madison Avenue, Mr. Watts?
Yes, sir. My wife's blind, too. Got 2 children at home.
Mr. Hill?
I'm not opposed to no OR bond, Your Honor.
Okay, I'm going to let you sign your own recognizance, which means you just sign a piece of paper guaranteeing you'll come to court. $1,500 signature bond. I've appointed you a lawyer, Mr. Morford. He will want to get in touch with you. You have a phone number where you can be reached?
Yes.
It's Jameson Watts, W-A-T-T-S is the name.
Yes, sir.
Thank you, Judge.
What's your phone number, sir? Mr. Morford's writing it down.
304-942-1256. That's my oldest daughter's phone number.
What's
What are the last 4?
1256.
13,
1256.
12,
56.
56. Thank you, Judge.
And that's not his number. Whose number is that?
Daughter's.
My daughter's Tiffany
Tiffany Watts?
Copley.
Copley, okay.
She's able to reach you quickly?
Yes.
Okay.
What's your availability in September? Mr. Moore?
Judge, I'm pretty good, except like, I believe the third week.
What's that, sir?
We're picking a date when your lawyer can be back here for your next hearing.
Your Honor, that case showed that it had a warrant on it, because it's not showing up on mine. Because if not, maybe it has a warrant somewhere else.
I don't know, do you have a warrant from any other court that you know of, Mr. Watts?
No, I don't.
I'm not showing anything else.
What date are you thinking, Judge?
22nd.
I'm here then.
Okay, Mr. Watts, do you know where the court is in Chesapeake?
Yes, sir.
Okay, you have to be here September 22nd at 10 a.m. If you don't show up, you get a warrant.
Okay.
September 22nd, 10 o'clock.
Okay, sir.
You'll get out of jail today unless you have a warrant from another court that I don't know about.
I don't.
Okay.
Thank you.
State of Ohio recalls Mary Johnson at the Lawrence County Jail, case number CRB 23-526.
You're welcome.
And April White is that day.
Mr. Smith's case.
Yes, I was just appointed judge, and the prosecutor's going to check on a temporary restraining order for victual.
We were able to reach the alleged victim, and he does not want her in jail. He wants her home. He also wants the charges dismissed. We're not ready to do that, but we're okay with no R bond and no protection order.
All right, Ms. Johnson, so you're going to get out of jail.
I need to go see my daughter.
Yes?
Oh, yes, thank you so much. Oh, thank you.
You're going to, so here's what's going to happen. You're signing a piece of paper that's a promise that you'll come to court as ordered. So it's called a own recognizance. You're guaranteeing your own appearance. So you just sign that, and then you come to court on the date that we pick, and you don't have to post any money. If you don't show up, you will get a warrant issued for your arrest, and when you're arrested, you have to pay the $1,000 as a penalty. What's the state, or what's a good date for you, Mr. Smith?
Judge, I'm here the 15th, 18th, 22nd, or 29th.
Let's do the 18th.
Yes, sir.
For pretrial. Okay, September the 18th. So, yeah, not this coming, well, 2 weeks from this coming Monday. September the 18th, you got to be in court. And nobody's going to call you or send you a notice. This is your only notice that you have to be in court. September the 18th. Did you get a phone number?
I did, Judge, and I will call you, Mary, at the phone number you gave me earlier, and we'll discuss it before the 18th. And I'll see you here. Try to get a little bit before 10 o'clock that morning, okay? I'll call you.
All right, September the 18th is your next hearing, 10 o'clock.
All right, I've got it. I'll write that down.
Stay.
I'm getting placed. I better write that down soon. I have a very crappy memory and stuff like that.
Thank you.
If you don't remember, there are phones
Oh,
here.
see, I'm not going to forget. I'm not going to forget.
I will call and remind you.
Stay home with my daughter.
Okay.
I'm going to remember you. I want to be there with my daughter.
State of Ohio versus April D. White at the Lawrence County Jail, case number CRB 2099. And Tad Johnson is on deck.
April White is Mr. Morford's case. Were you able to talk with her?
I've talked to her twice, actually, Your Honor.
Okay, well, let's wait on her to get on the screen, and then we'll proceed. Okay, Okay, we've got some we can call here. We'll do while we're waiting on getting this person back on the screen.
State of Ohio versus Cassidy Dorigo or Darigo, case number CRB 23487.
This is Mr. Morpher's case after pre-trial.
This is
Is Jalissa Scott here?
What can we do today on this pre-trial?
Your Honor, we had contact with the alleged victim, Jalissa Scott. We hoped that she would be here today because she indicated that she would be. There is a protection order in place, and because just 2 days ago she said she would be here and she's not here, we're not willing to, at this time, request that the TPO be dismissed. However, she also indicated that she would be agreeable for Mr. Darigo, or is it Darigo? Is that how you pronounce it? Dorigo, to do some anger management counseling. If he would be willing to do that, we would extend the case out and look at perhaps a dismissal later on down the road if there weren't any further problems and everything else worked out in a positive way.
As long as we can change the perhaps to it will be dismissed if I follow the anger management. I don't want it to be a maybe.
Well, there's no further.
And the reason I said that way was because we expected her to be here today and she's not here. So it would be easier to say with definite.
I can definitely go through anger management if it's a definite that it will be dismissed. I just didn't want it to be, I will go to anger management and it not be dismissed after. You know what I mean? That's the only.
Well, that's always subject to, if there's other events that occur, if there's additional problems, then there's no guarantee. I would say if you complete your counseling and there's no further problems, then I would think there's pretty much a guarantee it's going to be dismissed.
Yeah, and I did not mean it to sound arbitrary, like we would pull the rug out from under him. The only caution I have is because she isn't here today. Although day before yesterday, she was in favor of a 90-day continuance with anger management. So I guess if she showed up at a later date and said, here's why I wasn't here today, it was because of him, or something like that. And I'm not saying that's going to happen, but if there was some legitimate reason why we needed to change course. Otherwise, we will agree that if he does anger management counseling, does it successfully and no further problems, we would agree at the end of that to a dismissal with the payment of court costs. And if she wants the protection order dropped, then we'll need to have her come in, or I think that's the normal procedure, so.
Mr. Moore.
My client is agreeable, Your Honor.
All right. Mr. Dorigo, then we need to figure out how to get you the counseling. How do you pay for medical services, sir?
I don't
I don't
have insurance, nothing.
You can't get medical services. You don't have a medical card, you don't have health insurance?
I used to work at Ashland O'Charlie's. It just shut down. I don't know if you heard about that.
I did not.
So like the last time I saw you in court, I had a job I was notified 4 hours before we closed down, and it hurt. I'm being transferred to Barbersville.
Okay.
But the schedule there is, it's not going to be the same amount of hours. So I was making like $200 to $300 a week. Now it's
That'd be less?
Yeah.
You still live in South Point?
So I'm staying with my buddy in Flatwoods because the protection order.
Okay, but you consider yourself an Ohio resident?
Yes, yeah. Yes, sir.
Who can get, sounds like he could be eligible for a medical card. All right, I want you to talk with Taylor. She'll get you set up for some counseling. And then we're going to go 90 days out, come back, and if that's been successfully completed, no problems, believe me, there's enough other cases to go forward. If you come in with that kind of record, your case is going to get dismissed because we got plenty of other people that don't do that. So just do what you're supposed to, and your case will go away.
Understood.
December 1st is the next hearing, Mr. Morford?
I'm good then, Judge.
December 1st, there's a time waiver then.
So waived.
Is this with or without costs?
With, Your Honor.
With costs and anger management.
Judge?
Yes.
Could we ask for a different date? That's his birthday and he's scheduled to be out of town.
Okay, when will you be back?
I'll be back the 2nd, so you could do that. I don't know if that's a Monday.
December 4th.
Sounds
It's
great.
the Monday after. December 4th, 10 o'clock. Okay, we got April Watts on the screen now.
Good to go.
I'm sorry, April White. April White on the screen. Mr. Morford's case, case number 2099. And you indicated you had a chance to talk with her.
Twice, Your Honor.
So how do you want to proceed, Mr. Morford?
She left Ms. Reed, Your Honor, approximately 3 years ago amidst the beginning of COVID. She left against staff advice, as I understand it, due to health concerns for herself and also for children. I believe that the court's jacket reflects that she called in April 17th, maybe, 2020. And then she didn't show up.
I think she did call in that day, and it was one way to, she was supposed to then call in again on May the 18th, and it didn't happen.
And she, since then, Judge, has been cleaning house with her mother and is done with the old life. She's a Huntington resident currently, Your Honor.
Okay. Can she post a bond?
She doesn't have any money. As a matter of fact, she lost her cell phone, Your Honor. I don't even have a telephone number. I can get a hold of her.
Well, I think at this point, she's going to have to post a bond to guarantee her appearance since she didn't appear previously.
And Your Honor, we'd like for the court to consider something else too, and that is, we spoke with Isaiah White, and he is April White's son, and he says he hasn't had much to do with his mom since this happened, and that he feels that she still needs the treatment that she was supposed to get before. So we'd like to have her assessed too, to see where she stands.
Okay. Well, I can't require her to do that. I guess the only other option would be to offer the incentive of going to treatment with an ankle monitor, since she left against advice before and has been out of pocket for 3 years. The only way I'd let her go to treatment is with an ankle monitor now with an OR bond. Otherwise, I'd make a $2,000. If she doesn't want to do that, it's going to be a $2,000 cash assured bond.
Ms. White, do you understand what the options are that you have?
Yes.
You would be required to undergo an assessment for alcohol and other drugs. I'm not sure if the state's asking for mental health as well. And if treatment's recommended, you would do that treatment to the end. You'd finish whatever the recommendations were, and then the state would hopefully agree to dismiss the charge. But you have to comply with the court's orders first and foremost. I need you to understand that. And then Judge Capper would like a decision as to, are you able to make a decision now as what you want to do as far as bond? Do you want to go the treatment route? Or do you want to try to come up with a bond? Okay. Do you want me to get a hold of bail bondsman for you?
Yes, please.
How certain are you that you can post that bond, Ms. White?
I am, I'm certain.
Okay.
Thank you.
All right, bond's $2,000, cash for surety. I'll set the next hearing. What's your preference, Mr. Morrison?
Judge, I'm at your convenience. Whatever is best with you.
September 15th. So you have to be back in the court in Chesapeake, September the 15th at 10 a.m., Ms. White.
Yes, sir.
State of Ohio versus Ted Johnson at Lawrence County Jail, case number CRB 16684. Derek Blankenship is on deck.
It's Mr. Steyer's case. Want to recall? I assume you've had a chance to talk.
I have, Your Honor. I spoke to Mr. Johnson. He gave me the number. He is in jail right now in addition to this charge on a...
Right. Gentlemen?
Mr. Johnson?
Yes, sir.
Okay.
Yeah, okay. I'm sorry. He is in jail right now, both on this charge and on an adult parole authority holder.
I'm in jail. I went to see my parole officer, and my parole officer sent me to jail. As far as this disorderly conduct goes, I was supposed to call and come into your court, Mr. Capper. I just got out of prison on the 4th, and you get stuff around. My mom's sick, we just got a house. I had a lot of stuff going on, you know what I mean? So that, he never told me I'm in jail for disorderly conduct. That was never said.
Okay, I called your parole officer who he informed me that you are in jail on his holder. I don't know, I didn't talk to him about the details of the alleged violation, but I said to him that this case, which is a 2016 conviction, or 2016 case at any rate, predates.
Sir, be quiet, let your lawyer talk.
Predates the matter that he's on parole for. So the parole officer agrees that this matter has nothing to do with that. So what happens on this is not going to impact that. However, he doesn't know, due to the nature of his supervision, he doesn't know when or if a hearing on whatever APA holder is going to be filed. This matter is, I believe, an M4 disorderly conduct. It's several years old. I don't know if the state would be interested in, or I don't know I'm not sure how much time he had originally reserved.
I'm willing to just finish it on time served.
Then I think it's post-conviction.
Yeah.
Is it not?
Yeah.
Then I think that if you admit that your failure to appear, we would finish this by time served. Is that something you'd be interested in doing, sir?
All right, I sent you to time served. Your case is completed by jail. So you'll just have to deal with your parole violation.
Thank you.
State of Ohio versus Derek Blankenship, or recall at the Lawrence County Jail, case number CRB 22701. Justin Holland is on deck.
All All right, this is a recall on Derek Blankenship. I think the state wanted to look and see what other charges there were.
Yes, Your Honor, and he has, let's see here. He has charges that are pending in, it was on here, and then it timed out. Common Police Court, and there's a holder on him for that. So, and it may end up being, after we speak with Ms. Hankins, that we decide that we won't pursue this charge, but we're not willing to do that today, especially since he's in jail anyway. So we're not opposed to an OR bond. Do we need a protection order?
They said she's there and talking to her prisoners, so she went to person.
Okay. We have text messages from Mr. DeLauder, who's speaking with Ms. Hankins right now, and he's indicated to us that she says she doesn't want a protection order, so.
Okay.
And this is somewhat old, so we'll be okay. We'll agree to that.
All right, so Mr. Blankenship, I'm making your bond for this a signature bond of $1,000. Now, that's not going to get you out of jail, or it shouldn't, but we got to communicate
Yeah, I'm not going nowhere.
We got to communicate that to jail so they understand that we're making a signature bond only on this charge. He has charges in common pleas, and this does not affect that. So, making sure that's made clear. All right. And Mr. DeLauder is going to represent you, I take it. So I'm entering a not guilty plea on this charge, and I'll set it for a hearing September 22nd. For a pretrial at 10 o'clock. So let Mr. DeWater know that you have a pretrial coming up in this court. He'll need, if he wants to change the hearing date, he can do that and let you know.
Yeah, he probably would.
Eric Ferris. Kevin Conrad.
State of Ohio versus Justin Holland at the Lawrence County Jail on a recall. Case number CRB 23530.
Okay, do we have a urine screening result for Mr. Holland?
I have a journal.
Okay. Okay. What I was afraid of. All right, Mr. Holland, you tested positive for fentanyl and methamphetamine. Those are things that are really very prominent in our community right now and dangerous, especially fentanyl. Extremely dangerous. Have you ever been to treatment before?
No.
Do you have a West Virginia medical card?
I truly do not.
Do you ever go get medical services?
I don't know if I need it.
Well, that's the only time I expect you to go get it, but how do you pay for it? Do you have are you on Medicaid in West Virginia?
I think so. I ain't sure.
Okay.
I've been doctor now for how long?
Well, this fentanyl that you tested for is very dangerous. It's killing a lot of people. Over 100,000 people in the United States last year died of overdoses, and about probably more than 80,000 of the over 100,000 were from fentanyl. So, and you don't know when you're getting it. I mean, you may know you're getting it, but you can get it even when you don't think you're getting it. You think you're getting methamphetamine, and it's got fentanyl in it.
I didn't know that.
Yeah. Well, let's let you know this too. Anything out there off the street could have fentanyl in it. Even if somebody says, well, here's an OxyContin, take this. I got it from my grandma. Well, if you didn't see it come from the pharmacy, it could be a fake OxyContin, and it could be just pressed fentanyl. And people are dying from that. So, It's serious business. So I'm going to sentence you and order you to go get treatment.
Okay.
So you're in the west end of Huntington, right?
Yeah.
Do you have a car, or how do you get around?
Walk.
Is that how you got to Walmart? How did you get to the Walmart in South Point?
One of my buddies dropped us off to do grocery shopping, and he's supposed to come back and pick us up, and he didn't show back up.
Well, let me ask you this, did you want to get arrested at Walmart? Because I've been told that people with drug problems go there because if they shoplift and get away with it, that's okay. If they get stopped, then they get sent to treatment. Because if you want to get stopped for shoplifting, go to Walmart. I don't know why people go to Walmart. Because there's tour detectives and cameras, and they're set up to catch people, and they catch a lot of people. So,
That was a stupid mistake.
well, a lot of people are doing it right behind you. I don't know how many we had today. That's the place to go get caught. And if you got a drug problem, then I'm going to order you to go to treatment.
Yeah.
And that's what you need to do, because you're playing Russian roulette every time you take fentanyl. You know what Russian roulette is, I guess?
Yeah.
Okay, well, it's your life. And I want to give you the chance to get off of it, but there's a lot of places out there that can help you.
Yeah, I'm going to.
You want to talk to him, or?
Leslie was gonna talk to him and assess him, she could always switch his insurance over.
Okay.
Over do that.
All right, I'm going to have somebody call down and talk to you about getting treatment, and then I'll have you back out after that's happened. Okay, so I'll see you again here after a while. So somebody's going to call and talk to you about getting treatment.
State of Ohio versus John Cronin at the Lawrence County Jail. Case number CRB 23-244A and B, TRC 23-431 A, B, C, D, and E.
All right, this is Mr. Morford's case. You wouldn't know it was set for today. It had been a pretrial on May the 5th of this year, and it's alleged that Mr. Cronin did not appear. Warrant was issued May the 12th, and he got arrested on that warrant. All right, Mr. Cronin, your attorney is here. Mr. Morford, guess I should let you talk with him, see if he has any explanation for his non-appearance, that he's got an unauthorized use of a motor vehicle, possession of drug paraphernalia, and I believe there's an OVI here too. Yeah, there's an OVI. First offense with a urine screen, which we should have the urine result back now.
What's his name, Your Honor?
His name is John Cronin, C-R-O-N-I-N.
Is this one that was not originally on the docket?
Well, because he failed to appear in the past for a pre-trial. So.
We'll need to get that file out.
Okay, so we'll let the prosecutor get their file, let Mr. Morford call down, talk to Mr. Cronin, then we'll have you back, Mr. Cronin, on the screen after you talk to your lawyer, and here's the court's file.
The jailer will be recalling Derek Blankenship and Mr. Cronin a little bit later in the docket.
Ask him to put Cronin over by himself.
You can call Mr. Cronin out so Mr. Morford can call him.
Mr. Morford has some notifications. We're getting ready to call. State of Ohio versus Damian Fox, case number CRB 23-307 A and B. Damian Fox should be here.
He already has a bond revocation because he left Cardinal Health. He was at Cardinal on inpatient, was doing really well, and I made a mistake of taking the ankle monitor off. So, and he hasn't appeared today. This was his regular hearing date. So I think there's already been a warrant for hasn't been, it should be issued for Mr. Fox.
Thank you, Your Honor.
State of Ohio versus Zane Smith, case number CRB 2340.
This is Mr. Morford's case. It's my understanding he's at half now.
Yes, sir.
How's that going?
Pretty good, how are you?
Good. Yes, go ahead. You're doing.
Oh, sorry about that, Your Honor, I didn't hear you. What was that?
I just said, how's it going at half?
Oh, it's going good. I have a letter here for you today.
Good. Okay, so we're just getting started.
Yes,
At least
sir.
they will engage with the court. Pat.
Absolutely.
I've been pretty impressed with what they've done with other people. So
I like it a lot so far down there. It's definitely a different experience than Shawnee. I didn't enjoy my time there.
They're very uncooperative, at least
Right.
with the court. So Shawnee, I'm talking about.
Yeah.
Okay, so let's just go on and maybe come back in a month and see how things go.
Okay.
Mr. Morford, you agree with that?
Agreed, Judge.
October 6th.
That's good with me.
Okay, next hearing will be October 6th for pretrial at 10 o'clock. Okay, thank you, Mr. Smith.
Thank you. Have a good day.
Is that, you want your report back, or it's in the court's record?
What is it?
Do you want that report back, or you want?
No, it's fine. Thank you.
You're welcome.
State of Ohio versus Christopher Workman, case number CRB 22614.
Hey, Butch.
And Mr. Workman, do you have an attorney today?
I believe there was one appointed. I got a letter in the mail.
Did?
I didn't bring it with me. Yeah, I believe there was one in the mail saying one was appointed.
I think you're mistaken on that.
I may be.
Are you asking for a court-appointed attorney?
I'm not. I think that he's not going to show up, and we're trying to deal with it. Like I said, it was a family matter, and I think we're trying to deal with it through the family. So I'm hoping.
George Yates was the party. Is that a relative of yours?
My stepdad.
Okay. What's the state's position on this?
Well, we spoke with him, and he didn't have any medical treatment, which is a good thing. His position is that, first of all, he wants a conviction and a no-contact order, but he's okay with a suspended jail sentence. So that's what our position would be.
Okay. Are you in agreement with that, or you want to dispute it?
No, sir, I don't. I've got I work through a hiring hall, Boilermakers. We're scheduled to go to work on the 9th, around the 9th, John Amos and the Mitchell plant up the northern panhandle. And I'd just like to be able to go to work come around the 9th, guys, and get this plant if we could.
Well, that's fine, but we'll have to, I mean, this is going to be scheduled for another hearing that you'll have to appear. I'll try to work around your work schedule. When will you be back?
Well, like I said, they'll be hiring around the 9th, maybe a month or two after that, usually. But if I have to come back for a day of court, I will. But if maybe around the end of September or beginning of October, something, whatever you guys come up with. Be fine.
I'll set it for September 29th. So the state's not willing to dismiss this, so you've got a choice of either hiring a lawyer or, sounds like if you're working, you feel like you're eligible for a court-appointed lawyer?
Well, when I get back to work, I'm eligible now, I'd say. I don't have any income coming in, but.
Well, do you want me to consider you for a court-appointed attorney at this point?
Yes, please.
I have to determine your gross annual income. So do you file an income tax return every year?
Yeah, but I'm not employed right now. I think last year.
Well, I understand that, but if you're making $100,000 a year, and you're just not employed now, then you're still not eligible for court.
Last year, I think, income tax was 16 grand, I think.
Your gross was 16,000 last year?
I believe so, yes, sir.
And you haven't worked for a while?
No, I haven't, not since last year at Gavin plant, no, I haven't.
All right, I'm going to appoint Mr. Smith then, Roger Smith. You would be eligible. You'll have to fill out an affidavit that verifies your income.
Your Honor.
Yes, Mr. Healy.
Sorry, I didn't mean to interrupt, but I just want to make sure that I had imparted what our offer would be so that he knows that and Mr. Smith knows that. We would be, if he pled guilty, be asking for a 10-day jail sentence suspended and a no contact order for him to stay away from Mr. Yates. And we wouldn't take any position on any other sanctions, fines, or community service or anything like that.
How long would that be? And
Sir, it's probably best you discuss this off the record, because anything you say here can be used against you. When you tell your lawyer off the record, it can't be used against you.
Sorry, guys.
So, I've already, according to his work schedule, the 29th of September would be good. Is that a date you can be here, Mr. Smith?
I believe it is the 12th September, yes, I'm here 29th September.
All right, September 29th is the next hearing, 10 o'clock for a pretrial. Thank you. Talk with Mr. Smith.
Thank you, Judge.
You're welcome.
State of Ohio recalls John Riggs, case number CRB 23528.
Okay, it's a pretty bad screen, Mr. Riggs.
Yeah, I need some help. I'm on
He's a Kentucky, you're a Kentucky resident, right?
Your Honor, I've got him Mr. Brown's card, and he's going to contact Mr. Brown to set up an assessment.
Okay.
I go to a Suboxone clinic. I get prescribed Suboxone, but
Well, that's not going to help with all the other stuff you're taking.
I think it's, I need some help.
Well, the place that we do a lot of work with for Kentucky residents is called ARC, Addiction Recovery Care. And a lot of times they have a representative here, but today they don't. Jeremy Brown is usually here. I think you've got his contact information, so I'm going to order that you get in touch with him.
Okay.
I'm going to go ahead and sentence you, and I'm going to make that, well, you know what, I'm not going to sentence you because you got a bond up. So if I sentence you, that terminates your bond. So here's what I'm going to do. I'm going to delay sentencing. I'm going to let you go ahead and get in contact with Mr. Brown and get something set up on treatment. And then I want to have you come back and I want to see what you're doing on treatment.
Yes, sir. Yes, sir.
And it says on here you got a good job. Where do you work?
I work for Haverhill Windows in Franklin Furnace, and I've been there since December, and I make good $22 an hour. And
that's good.
Yeah, good job. And I was going to tell you, my wife went through ARC. We have a child, a 30-month-old daughter, And she went through the nursing, she went through, when she had the baby, she's clean now. She's been clean for 4 years altogether.
Okay.
So she knows about ARP too, so she's.
Well, I'm sending you a place you're familiar with. And you've got this baby now, and you've got a lot of reasons to get clean.
Right.
So I'm kind of surprised, you did not test positive for fentanyl, but you tested for a lot of other stuff. And the problem is, I've said here before, you get any of this stuff off the street, with some of this is street drugs you're obviously getting. I'm kind of surprised there's no fentanyl in it, because they're putting fentanyl in everything now. So, and that's deadly stuff.
Yes, sir.
So you got to get clean, get off, you know, you've got a lot of reasons. You got a good job, you got a baby, you got a wife, and you using is going to affect that baby and it's going to affect your wife. You're going to make it harder for her to stay clean if you're using. You need to be both on the same page as far as getting in recovery and staying there. So you need to work on that together.
Yes, sir.
You need to be supporting her in her sobriety, and you got to get clean.
Yes, sir.
So I'm going to give you a couple weeks to go get with ARP and come back, and then I'm going to sentence you. And the thing is, the reason I'm not sentencing you now is because you got a bond up. So if you don't show up, I'm going to tell the bail bondsman he'll have to go fetch you.
I'll show up for sure.
Okay. So let's make it then the 15th. September 15th for sentencing. And I'm going to send a copy of your screen to Jeremy, so he'll have that. Now, you got to be honest when you go in there and tell them all, because I have people who say, well, I don't really know why I'm here, the judge has sent me here. You need to be honest about what's going on.
Yes, sir. Thank you.
Be back here on the 15th, and we'll, you know, I want to see you get clean. I want to, you know, the better you do, the better I'll do on the sentence. But
Yes,
the
sir.
main goal is get you clean.
Yes, sir.
Okay?
All right.
15th at 10 o'clock
Okay.
is your next hearing.
I
Your
just-
bonds continue as posted.
I just let Mr. Showers know that I come back the 15th. Just let Mr.
You don't have to let him know, because what'll happen, he doesn't care as long as you show up.
Okay.
But if you don't show up, I text him a copy of the bond, and he knows you didn't show up, and he'll start looking for you. So
Okay.
as long as you show up, you'll be fine. Just show up when you're supposed to.
Okay.
And get in touch with Mr. Brown right away. Don't wait until the 14th of September to contact him. I want you to do it today.
I'll do it today.
Okay?
Thank you.
You're welcome.
State of Ohio recalls Cassidy Dorigo, case number CRB 23487. Cassidy Dorigo.
I'm pretty sure he left.
Requested the prosecution.
He left.
Okay. This is Mr. Morford's case. I think Mr. Dorigo's already left. It was set on a 90-day continuance.
Yes, and we wanted, if the court recalled, this young lady hadn't been here, and she indicated she would be. Apparently she was and didn't hear me call for her. So let me, if I may, speak to her for a second. This is Cassie Dorigo.
Does she want to drop the protection order?
She does, Your Honor, and I discussed with her the other things that we had proposed, the anger management counseling, and coming back on December the 4th, and I believe she'll say that she's in agreement with all those things.
And no one's pressured you to drop the protection order? Okay, it's your request, ma'am. This is on Cassie Dorigo, 23487. I'm dropping the TPO protection order. He's coming back December the 4th, and the state's promise if there's no further problems and he completes an anger management course, they'll dismiss the case with him paying court costs. You're agreeable with that? Yeah. Okay. You're welcome to be here at that hearing, or if you feel like he's not honoring what he's supposed to do, if you want to report that to the prosecutor before then, we can try to speed things up and get him back in to make an adjustment. Okay. Thank you.
Thank you.
Thank you, Your Honor.
State of Ohio recalls Corey Cordell, case number TRC 23906, A, B, and C.
Okay, this was on a plea, and I asked for a urine screen before I did the sentencing. Have you seen the results?
I have not, Judge, but I do, if I may approach you, have the proof of insurance that he was
Okay.
asked to go get from his car. Your Honor, I've now seen the urine screen results. My client indicates he just started at the Huntington Treatment Center, the methadone clinic there in Huntington, Monday?
Yes.
Just this week.
I understand maybe why you would do that, but I don't think it's a good choice.
Like I can't like I've tried detoxing other ways. It's just
Well, there's other choices that, and to tell you the truth, I've said this before, I hope I'm not going to get sued by Huntington Treatment Center, but they just pass out methadone, whatever you want, they'll give it to you forever. They do no counseling that I can detect. There's no effort to help people other than just pass out methadone. So I think there's a lot better options.
it's better than fentanyl.
Well, it may be better, but there's, that there may be, it may be better than what you were doing before, but there's better options than that. So that's why I want to see you, get clean. And there's medically assisted treatment other than methadone. You tested positive for fentanyl, and you probably heard what I've said about fentanyl.
Yes, sir.
So that is an opioid. It's a synthetic. It's very dangerous. It's 50 to 100 times stronger than morphine or heroin. And you're just trusting the people that are cutting it. They're cutting it way down. But, I mean, we're not talking about scientists or chemists or anything. We're talking about people doing it in a garage or a warehouse somewhere. So you're putting your life in those people's hands. And a lot of people are dying because of it. So you are a West Virginia resident.
Yes, sir.
Are you working? What's going on with you?
No, sir. Not at the time.
Okay. You got secure housing?
I stay in between my fiance's mother's and her father's house. One's in Proctorville and the other's here in Huntington.
Okay, well, maybe we need to get you some secure housing and get you cleaned up, because I don't know, but if my daughter's fiance was using fentanyl, I probably wouldn't like him hanging around my house until he got clean.
Fair enough.
Right? You have a medical card?
Yes, sir.
West Virginia?
Yes, sir.
Taylor? Okay, I'm going to refer you to Taylor for an evaluation. Let's do a little mini assessment, have you come back, and we'll decide how we're going to proceed. So she's out in the lobby waiting on you.
State of Ohio recalls Edward McCoy, case number CRB 2328, A, B, and C.
Edward, you were doing so good.
Yes, sir, but the only thing I've been taking is my cold and flu medicine. I don't know how that comes.
Your cold and flu medicine has methamphetamine in it? I don't think so.
It's Tuesday, but I haven't been doing that, what it came up. He said something about the Sudafed that showed up like that. I don't know.
Okay, I'm ordering you back to RRG. I sent a copy of your screen to Mr. Webb at RRG.
Nick.
Nick, yeah,
Okay,
Nick.
he's my recovery coach, so.
Yeah, so he knows.
You want me to go
I'm
down
going
there?
to tell him that you're coming back, and you need, obviously you need some help.
All right. I'll go down there when I leave.
You were doing so well. I want you to go back and see them, and let's figure out, I want to have you back in a week.
All right.
So you go see Nick, and come back, I'm going to tell him your order back here next Friday, September the 8th.
Next Friday.
At 9 o'clock.
All right.
Okay, go see, contact him today. I've just sent him the screen, he's going to know about it. You got his contact information?
All right. Yeah, he's my recovery coach. I got
Okay,
everything.
so you know how to get in touch with him. He's not going to be shocked because he's already seen it.
Okay.
Okay, see you in a week.
State of Ohio recalls Justin Holland at the Lawrence County Jail, case number CRB 23530. John Cronin is on that.
All right, Justin Holland. All right, Mr. Holland, you tested for fentanyl and methamphetamine. Do you have a medical card from West Virginia?
Leslie did pre-assess her. She's in the back right now.
Oh, okay, so you did talk to somebody for treatment?
Yes, she said that he's going to need residential and she can pick him up from the jail today.
All right, you willing to go do residential treatment? Okay.
Sorry.
All right, here's what I'm going to do. I'm going to sentence you. I'm going to give you a suspended sentence as long as you do your treatment. That's going to be the next thing. What's the name of her facility? I'm sorry.
It's Shawnee.
Shawnee. All right, $100 fine. I'll suspend the fine as long as you complete treatment. Order you to pay the court costs. 180 days in jail. So I'm giving you 6 months in jail, but I'm going to suspend all of it on the conditions you complete residential treatment at Shawnee. You're going to be released to them for inpatient today. And then I'll set a review hearing for you in a month. So let's make it October 2nd. And they'll transport you. You don't have to worry about getting here. They'll bring you. It's just a hearing for me to check and make sure you're doing what you're supposed to. Any questions? Okay.
Have community service.
Yeah, let's do 5 days of community service. Oh, I forgot the most important thing. Your order to stay out of Walmart. That's tough to take, but that's the thing. I don't know how they're still in business. I've ordered thousands of people to stay out of there, but somehow they stay in business. Okay, I'll see you on October 2nd.
All right.
Take advantage of this and get clean.
State of Ohio recalls John Cronin in Lawrence County Jail, case number CRB 23244A and B, TRC 23431, A, B, C, D, and E.
This is Mr. Morford's case. The allegation is that Mr. Cronin failed to appear for a pretrial May 5th. And Mark's been outstanding since then.
Judge, I just learned this morning, or would have tried to obtain some medical records or proof for you. He informed me that on May 12th of this year, he was involved in a serious ATV accident, was treated at Grant Hospital, had some kind of procedure to reconstruct an ankle, was in a medically induced coma for a couple of days. I was just informed of this, I don't have a medical release, but that's where he says he was in May.
Did he turn himself in to authorities, or was he arrested on warrant?
I believe he drove, Judge. How'd you get picked up, Mr. Cronin?
I was arrested last night.
What were you doing?
Driving to see my lady.
Well, he's gonna, one, I'm ordering, he had a $10,000 signature bond, so that's ordered $4,000. And set a new bond of $2,000, cash assured. So I'm gonna guess he's probably not getting out of jail. When do you want to come back for the next hearing?
Soon, I don't think, I'm the same opinion of you, Judge, as his ability.
Next week, September the 8th.
That's fine with me, Your Honor. Mr. Cronin, do you think that you can post that bond?
Well, he's got to pay $10,000 first.
Well,
see, he's owes.
We'll see you Friday, Judge.
$10,200 probably.
You don't have a nice nest egg laying around, do you?
So his new bond here is 2,000?
2,000, but he's got to pay the old bond of 10,000. That's forfeit. So September the 8th is his next hearing, pre-trial. I think this was, so to be ready for next Friday, I'd like the state to get this urine, should have the urine results by now.
I would say we do. And I've asked Mr. McClellan in our office to check into that for us.
Okay, next hearing, September the 8th.
Thank you, Your Honor.
You're welcome. Okay, that finally finishes this up with the jail. Okay.
State of Ohio versus Travis L. Shalyers, case number CRA 22791, CRA 22418, CRB 22420.
Let's go.
May I approach, Your Honor?
Yes, this is Mr. Morford's case, preliminary hearing. Okay, good report with stuff still being worked on. That's the way I take it.
Yes, Your Honor.
Agreed.
you working now, Mr. Salyers?
Not yet. I've got to wait till my 126.
Day 126.
Day 126.
Which, you know when that is?
He was a complete restart. The second go around was 6/9, so we're looking at about 2 more months.
Okay. Let's come back then, maybe mid-October.
Okay.
What's your schedule then, Mr. Morford?
Judge, I don't have any trials scheduled so far then.
Okay. And if somebody tries to schedule a trial, you're gonna say, well, wait, I've got something in municipal court that day.
Yes, Your Honor.
Okay.
You got it.
October 16th.
Thank you, Your Honor.
Hearing.
Thank you, Judge.
Good job, Mr. Sayers. Keep it up.
Thank you. State of Ohio versus Melissa Dempsey, case number TRC 21-1044, CRB 21-291.
Okay.
Your Honor, if I may, this is Mr. Thompson's case. I noticed it on the docket and contacted him because I hadn't seen him here today. He wasn't aware that it was set today, and I think I overheard Ms. Dempsey state that he wasn't here the last time it was on, so I'm betting that what happened is it was set today, and he just didn't hear that it had been reset. He asked me to stand in for him this morning. I'm not familiar with the case. He's going to be here on Monday. Could you be back Monday?
I just started a new job. I'm already late for work now, and I don't know if I might have work.
Your Honor, I have a note that on 7/28, she was ordered to do some community service before her next hearing, and she's not showed up.
Yes, he said I could do it in Ironton. I did go to Ironton. I actually had to weed eat with the guys there.
At that municipal court?
Yeah. Yes, I did.
Check on that.
I do not have that. I can check into it.
What, do you know what your schedule is going to be, or you work?
Yeah, that's what I was looking, my boss in it, and I think it only goes this Monday though. Actually, it only goes this Saturday.
Okay.
But I mean, I could ask to be off.
Well, he's going to be here Monday. I don't know if that's even convenient for the court, but, well, actually, it will be Tuesday next week because I forgot about the holiday. When I spoke to Mr. Thompson, he said Monday, so I assume that means he's already on the docket for Tuesday. If not,
why don't we go to the 11th?
if you could set a date, I can just communicate it to him, and he can, if that's going to be an issue, he can take further steps.
I'll set it for September the 11th at 10 o'clock for sentencing.
Thank you, Your Honor.
Well, you'll let Mr. Thompson know.
I will.
All right, thank you.
Thank you.
State of Ohio versus Daniel L. Cox, case number TRA 23495, TRC 231103. Mr. Roger Smith's case.
This is a case that has, it's a felony and an OVI. My understanding, to speak with Mr. Hield, is if my client were to plead no contest to the OVI, that they would agree to hold the felony in abeyance, let him complete treatment. You're in treatment now, right?
Yes.
He's just started treatment, and then we would come back for sentencing at a later date and hopefully take that treatment into account as opposed to isn't the necessity for the 3-day school. But that's my understanding what the state's position is, and my client's wanted a no contest plea today to the OVI and delay sentencing.
Is there a stipulation to finding him guilty?
Oh, yes, Judge, yeah, we'll stipulate to find him guilty, yes, sir.
All right, I'll accept that plea if Mr. Cox agrees with it. Do you agree with that plea?
Yes, sir.
I'm going to delay sentencing. Where are you getting treatment, sir?
PROACT.
Okay. I don't suppose you got a report?
No, I just signed a release yesterday.
I'm going to need a report. They've gotten to be a little difficult to get reports out of, so I'd like to have a report the next time you come back.
Can I bring it?
Yeah, you can bring it or they can fax it in or however. I just need something official looking on a letterhead from, tell me what you're doing. or not doing. Either way. September 29th, I think you're already here.
I'm here, Judge.
Because we're just getting started, I'm going to set it for fairly quickly. September 29th will be the next hearing. I'll be looking for a report from ProAct.
And Your Honor, I do have a...
That'll be a sentencing hearing.
Okay. I do have proposed entry for driving privileges, limited driving privileges, if I may approach.
Okay.
I do not.
As it indicated on the ticket, he did not show financial responsibility, so this is not going to be effective unless he shows it.
Yeah, I'm not going to sign it until he brings
Keep
it.
in the file, thank you. Bring it in, then he can sign. Make sure you bring it to the court.
Okay, September 29th is the next hearing.
Sir, I also had a review hearing today.
Oh, that I don't know about.
Okay, was it called earlier, or Daniel Cox, right?
I never heard it.
It wasn't. I don't have it. It wasn't on the list.
Let's look under his name and see. Sometimes cases get missed. Okay, you did, on a theft offense. It's an old case, right?
Yes, 08, CRA.
What, have you done anything on it since the last hearing?
No.
Okay, why not?
I just was supposed to do it today.
I'm sorry, I didn't hear what you said.
I was supposed to pay it today.
Well, you got community service to do too.
I never knew that.
It's right on the judgment entry, 5 days community service. There's restitution to Harold Maynard. Do you have a payment on that?
I will at 4 o'clock.
Well, I don't think we're going to be here at 4 o'clock. It's probably the only court in session today anyway. Okay, I'm going to continue that to Monday. Bring it in Monday. Your review hearing is continued, well, not Monday, Tuesday, because Monday's a holiday. So September the 5th, 9 o'clock on that. Set it for, put it on the docket then for reviews. Tuesday, September 5th, 9 o'clock. You can pay them.
And I have the ability to find that file.
Just put it on for Tuesday. Okay, that's all.
State of Ohio versus James C. Thompson, case number CRA 23306, A and B.
Yes. Well, I'd say it's a really good report.
It is.
Mr. Thompson's compliance requirements include, well, that's not the one I want to read, but it was. Mr. Thompson consistently meets and exceeds all treatment plan requirements. That's really good.
Yep.
Meets and exceeds, so you're going above and beyond, so I like that. Good job.
Thank you.
Do we still need to continue, or what's the state's position on it?
Well, Your Honor, and I reminded Mr. Smith of this before the hearing, that because these are felony charges, we weren't willing to just dismiss them outright. At whatever point it's determined that it's the appropriate thing to do, we would amend the charges to misdemeanors if he were to plead guilty to them, and we would recommend, if he were to do that, a suspended jail sentence, a substantial suspended jail sentence as a convincer to make sure he finishes his treatment and finishes treatment. That would be our offer, and I don't know if today's the day to do that or not.
Well, the report is good, Judge. I think you want to do that today?
Yeah.
We have no hesitation. If they want to amend it, they do misdemeanor, because that was the end goal anyway. With suspended jail time, he would do that, and he intends to fully complete treatment.
and maybe even delay sentencing on the misdemeanors. We got 2 of them. We wanted to succeed, and we wanted to be reminded that what the consequences might be if he would not succeed.
Well, and this involved your 2 kids, right? So
Yeah,
they got to be happy with what you're doing.
yeah, they are. I got 109 days under my belt without drinking.
Okay, very good. All right, I'll allow this to be amended to a misdemeanor. And one thing I want to make sure you understand, because I think this was already the case because you'd had a prior conviction in the past.
Yeah.
That if you get another charge, it's probably going to be a felony. It's not going to be a misdemeanor.
Yeah, I understand that.
You understand?
Yes.
So, well, yeah.
There's 2 of them.
Okay, there's 2, an A and a B, make them both M1s. So it's going to go on your record, and if you get another one, it'll be enhanced. It's, I mean, almost automatically it's going to go to a felony.
Okay.
So the best thing is, don't get any more.
Well, I'm not.
Okay? And it sounds like you and alcohol don't mix.
No, I don't. That's why I quit.
So that's the first step, is realizing that.
Yeah.
And then making an adjustment, so you don't put yourself in a position. Okay, I'll allow the amendment to Mr. Means. Is there anything you want to tell me before I finish it?
I just want to thank you all for showing me the way to change my life.
Thank you for taking advantage of the opportunity, and I hope it makes a difference to you and the rest of your family. Okay, I'll impose a $100 fine, order you to pay the court costs, 60 days in jail suspended, order you to complete counseling with RRS. There's no protection order or anything requested.
No, Your Honor.
2 years of level 5 probation. So I'm not going to have you coming in other than for a review hearing.
Okay.
And you've done well, so I'm going to set one down the road. I'm going to make it November the 10th. So once you come back then, I'm just going to check to see that you're doing what you need to do with RRS. And that will be a review at 9 o'clock. And that same sentence on both cases. Go check in with Mr. Cooper for probation, and then you're free to go. Any questions, sir?
No.
Okay. Good job.
Now you got 2 of them. Thank you, Judge. Thank you.
State of Ohio versus William E. Smith Jr., case number CRA 23327, A and B. Mr. Stiers, yes.
Okay, this is Mr. Stiers' case. Okay. Sounds like there's progress, but still stuff to work on.
Yes, Your Honor.
So come back in another time frame,
Your Honor,
maybe mid-October.
October, I'm here the 16th.
That's fine, October 16th.
Thank you, Your Honor.
Be the next
Thank you.
one.
Good job.
Keep working.
State of Ohio versus Devin Stapleton, case number CRD 23494, A and B, and CRA 23491.
Mr. Stiers' case?
Your Honor, we might want to approach on this one.
Yes.
Can you fill that?
everyone in Port Clinic wants to accept. Since everything's on our table, Mr. Hill?
Your Honor, if it please the court, we have done some in-depth looking at this situation. And one thing that we learned about is that Mr. Stapleton continued to contact the young lady that was the alleged victim of this after he was told by the court not to, and after there was an order for him to stay away, which is very serious and can cause a person to go to jail very easily. Had I known this before yesterday, I might have gone ahead and had charges filed and asked for him to be arrested. We want primarily for him to leave the young lady alone, no more messages of any kind, no attempt in any way to contact her or anybody else involved in this. We also understand that there is an evaluation pending, and so I guess we'll just have to wait and see how that goes. But other than that, we just need for there to be no problems.
And Your Honor, there was an issue with the evaluation due to the nature of the charges that are currently filed. I thought the state might have a motion to that effect.
I mean, we can nolly that charge with the right to refile it if that is a sticking point at this point.
I believe that is a sticking point, and I recognize, and I'm not sure that I
you
can
can get the evaluation done then if there's no charge pending.
No, there's a misdemeanor pending as well, I believe, is there not?
There is a CRB case number.
I think we can have, let me look at
2494A and B or
Yeah, there's aggravated menacing, and then there's an assault.
Right.
As well as the abduction.
Those would allow they could do the assessment on those. And should this end up not being something we can handle here ultimately, a nollie would not stop the state from refiling at a later date and taking it on to the grand jury if they needed to.
Your Honor,
this would allow us to move forward on an immediate basis.
Does that message from Court Clinic indicate that that they can't do the evaluation as long as that charge is pending?
It doesn't say that. It doesn't even mention the fact that there's a difference in the charges. I mean, it really makes no sense, but why they would take that position.
My understanding, and I think, what is the date on the email, Your Honor?
August 21st.
So I'm not sure if that's before or after I spoke to Court Clinic on the phone. What they told me is basically that if there's a felony pending, they don't want to do the evaluation
Until there's an indictment.
Until there's an indictment. And I said, well, I can't take him through this process when I don't believe there's when I have a question of competency. So I can't go forward. They said, well, we can't do anything about it if we find him not competent. There's nothing we can do because there's not an indictment charge on us. And the charges are filed. They're filed at the lower court level. He is on a bond. He is subject to the court's control. And that's where I ran into the issue. If Mr. Hield wants to contact Court Clinic and look into this further, I'll be back here Tuesday.
We'll do that.
Well, actually, it might be better to do that Friday than Tuesday, simply because I don't know what time we'll finish here today, and I assume they'll be closed Monday. But
We'll put it on the 8th, and Mr. Stapleton doesn't have to be here then for that. There's no reason for him to be here for that hearing. It's just going to be a matter of determining whether the felony is going to be knowledge or not.
Correct.
But I will admonish you, Mr. Stapleton, you were ordered not to contact or go around the other party. So there's been an allegation you sent some messages, so you can't do that. You can't send messages to her. You understand that?
Yes.
Okay. So I'll put it on the docket for September the 8th. Mr. Stapleton's welcome to be here. He's not required to be here. Then we'll schedule a new hearing date after that.
Okay.
Thank you.
Thank you. Got just a second, Your Honor.
Sure.
State of Ohio versus Taylor Bryan, case number CRB 23-112, CRB 20-112. Taylor Bryan.
Your Honor, on that last case, can we get a copy of that email? So I'll know
Yes,
who to
it's
contact.
in the file.
You get that, Jasmine?
All right, this is 23-112 and 21-112. Looks like you missed a hearing on August 25th
Friday.
on a theft offense. So you have done 1 day of community service since the last time you were here.
Yeah, and I paid $20 today.
I do see that. Okay, your next hearing is going to be October 2nd on both cases at 9 o'clock.
Thank you.
You're welcome.
State of Ohio recalls William Gullett, case number CRA 0972.
Your Honor, he never showed up.
Okay. He's out, he's working, he's on outpatient.
Yes. He just started taking college classes too.
Okay. he's got 7 days to get in before warrant issues.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio recalls Joseph Edens, case number TRC 21-1918. Joseph Edens.
Joseph Edens. Be a warrant issued in 7 days for failure to appear. What?
He's with Nick.
That's what I
I
said.
took him there.
Oh, okay. So he's already there?
Yeah, I took him there a couple weeks ago.
Well, so we need a report from them. Okay, yeah, he's the bicycle guy, right?
Yes.
Let's continue Edens to September 8th.
He used to be a Golden Glove boxer, Judge,
Is that right?
back in the day.
So I'm texting Nick.
What's his case number?
21-1918. Put it on the docket for September 8th for review.
State of Ohio recalls Corey A. Cordell, case number TRC 23906, A, B, and C.
All right, and the assessment is he needs inpatient?
He does, but he is very resistant to coming off methadone and does not want to do treatment.
I spoke with my brother.
Judge, we've entered the guilty plea. I don't know at this point, if he doesn't want to do treatment, what the other option is. I guess
Jail.
jail's an option. 3-day school jail.
It's a 3-day school.
Three.
What is a 3-day school?
It's a DUI school. It's unfortunate.
You need to do the treatment now, because I'm not going to give you 3 days in jail. It's going to be a lot longer. You're risking your life.
Like, what's the treatment options?
Inpatient, well, residential.
It is residential.
For how long?
6 months.
I'll consider try. I'll take it day by day.
I mean, I'll take you today.
Okay.
Okay, so we're willing to do it?
He's going to go today,
It's
Judge.
a smart play.
I agree.
Give it a chance. Wait till your brain needs to clear up a little bit before you make some long-term decisions about what you're going to do. Just try this and give it a chance. Okay, on the OVI, I'll impose a $500 fine, and I'll suspend $125 if you complete treatment. So that takes it to the minimum, where you pay the court costs. Your license suspension will be 6 months. 180 days in jail, all suspended, on the condition you complete treatment. 5 days community service. If you complete treatment, you don't have to do the 3-day school. Inpatient treatment. Review hearing, September 15th, 2 weeks.
Thank you, Your Honor.
Thank you, Judge.
There's some other, wait a minute, there's some other cases.
Some other cases.
He's got a B and a C, I think, too. Yeah, he didn't have a driver's license, driving under suspension.
Oh, yeah, they were suspended for 3 hours.
$50 fine. And then on the expired plates, $30 fine. See Mr. Cooper, go with, are you taking him or not?
I'm going to have someone else come pick him up.
Okay, you'll get transported here in a few minutes.
Thank you, Judge.
Thank you, Your Honor.
Next time he comes back, he'll be in the man.
State of Ohio versus Patrick Jones, case number TRC 19378, A, B, and C.
It's on a sentencing docket today. Mr. Smith's the attorney.
Yes, Judge, I was 4 years ago. I'm not sure where we are at this point on sentencing.
Well, it's actually more like a review.
Okay.
He had a bond up is what happened.
I see.
He got picked up on a warrant, so he's supposed to be with RRG. This is the third one of their clients that were here today with no reports. It's like, what have you been telling me? Are you still going to RRG?
Yes, sir. I just actually completed today. I haven't got my certificate, but the next time I show up, I'll have it. We had an 8 months course to do, and I completed it.
Okay, you have community service and fines to pay.
I'll pay all my fines today.
What about your community service?
I need to start doing that.
Okay, when? When are you gonna come out?
I'll come tomorrow.
Okay. Next hearing is October 2nd for sentencing.
Thank you, Judge.
Thank you, Judge.
You're welcome.
State of Ohio versus Cameron B. Harris, case number TRC 2348, A, B, and C.
Yeah, approach your honor.
Yes. Okay, there's some good stuff in here and still stuff being worked on, so I'd say we need to continue monitoring. Does that agree?
Yes, Your Honor.
October 6th for sentencing.
State of Ohio versus Jennifer Collins, case number TRC 194073, CRB 24.
You don't need nothing.
Mr. Stratton's case?
Yeah, Your Honor, she's just paying on fines and costs. Paid on it. How much she paid?
Well, what about the community service too?
It's done. It's done. It's done.
It's done?
We sort of go through that every time we're up here. It's been verified that she's got it done. So that's completed. All she had was a balance of $297. I think she paid $50 more, so it should be a balance of about $247.
paying something today?
She just paid on Tuesday, Your Honor.
Okay, August 30th, she did pay 50. October 6th. Percent. 10 o'clock.
Thank you.
October 6th. All right.
State of Ohio versus Ryan D. Johnson, case number TRC 23-317, A and B.
Good morning, Your Honor.
Your Honor, I just sent you
Afternoon
a,
now.
Yeah, well, I know, it's just I got here at 10, yeah, afternoon, my bad.
I just sent you a letter on this morning, Your Honor, from
RRG.
You want to say RSS?
Yeah.
RRS.
Yeah, right.
You emailed it, or how did you send it?
Oh, I texted it to you. Oh, short of what?
No, he's one of the few that got a report.
Because I asked for one.
Yes.
Is that one you sent me, Sean?
I did. Sorry. I didn't send it to you.
That's okay.
You got the
I
last
got
one.
some
Okay, it
from
says
somebody.
he's completed and discharged.
So, Your Honor, we could possibly wrap it up today. That's what I said for another. Come back except for another 300.
Well, for someone with your history, your smart remark was not appreciated.
Oh, my bad. Sorry.
Yeah, not a wise thing to do.
Okay.
What's the state's position?
Your Honor, I'm looking at when he would have actually started the treatment. It looks like in May. So I haven't seen what the report says. It sounds like he's completed their programming.
He's been there since June 5th.
So I mean, on the one hand, it's a good thing that he's done what they asked of him. The other side of that is that this is a third offense with a refusal and an additional in 20 years. So this is it starts out as an enhanced, very much enhanced potential penalties. Frankly, when I looked at this, I didn't anticipate that they were going to say he was done already with treatment, and so I wasn't prepared. I hadn't formulated what I would want to recommend on behalf of the state in this matter. It is a serious matter. Not quite sure what to say at this point. I think that at this point, I think there's some jail time that's owed. It's admirable that he's done the program, so I don't know if there's somebody here from the, that can speak to the,
Whatever the 6th is.
He's also, Your Honor, scheduled to get the Vivitrol shot on Tuesday.
The 6th.
Wednesday. Yeah, so.
at your RRS?
No, I'm going.
I sent you the letter.
Oh,
RRG.
Okay.
There's too many RRs.
That's through his primary doctor, but not through the.
It's going through Highline.
What is that high on? Is that
It's through Valley Health.
Valley Health?
How's the state going to proceed?
Well, it's my understanding that he's going to continue to receive treatment from Valley Health. So we'd like to track that a little bit longer to see if he continues to show the improvement that he has so far.
Your Honor, we have no problem with that. I don't know if I think there's some counseling that comes with the Vivitrol shot.
I don't know. I'm gonna go on Wednesday, and I have to go to a liver specialist.
Oh,
So,
okay.
yeah.
Yeah, so he'll bring a letter, for sure.
I will.
Okay,
Okay.
yes.
All right, so another month,
Yes,
October 2nd.
yes.
Sentencing, October 2nd, 10 o'clock.
Thank you.
You're welcome.
We'll do that then.
Okay.
State of Ohio versus Daniel Craig Collier, case number TRC 23448, A, B, and C. Do not check in towards Mr. Steyer's case.
Your Honor, Mr. Collier,
He was on there, let me see.
would be presented by video
Yeah.
if he's here.
Well, he was on there. Let's see. Doesn't look like he is now.
Okay,
He
well,
was on earlier.
what we were doing today was checking on the status of his treatment. I have received a fax. I don't know if the court got one too or not. I got a fax from Rocking Horse, which is his treatment provider in wherever he is. Springfield. And although I'm warned quite vehemently not to redistribute this, I think the purpose that I got it for was for the court, so we're going to go ahead and provide that to the court. If he's not on there now, I would ask that we reschedule this, but at this point, the court will actually have a report. And my apologies that he's not on there at this point.
At one point, it looked like he was laying down. Did you see that? So I turned off his camera, and then he decided he was going to disappear. was looking at the 22nd, we already got 10 sentencings that day, so that makes sense. And which days are you not here?
I'm not here the 11th and the 15th. I'm here that day, Your Honor.
Continued is September 29th. Tell him not to give up hope when he gets on there. He's got to stay on.
It's a long haul.
Yes.
You gotta take court appearances like sobriety, one day at a time.
Yeah. 1 hour at a time.
One case at a time.
State of Ohio versus Mary Hampton, case number CRB 23321, CRA 23320. Mr. Schreier requested that we put
Your Honor,
up
may I-
a motion today.
Yeah, Rich.
Yes. You? And it looks like earlier in the week she was positive for methamphetamine.
Your Honor, at this time, on Monday when we were here, I tested her after she had been seen in court and she tested positive. I requested that she go into inpatient and she has refused to do so. She asked to speak with her attorney, so I asked her to be here today, had it put back on the docket for today. She tested positive for amphetamine and BUP today. And asked her to go into inpatient again, and she still is not refusing to do so. If she's not going to follow requirements, we're going to discharge her from QRT.
Okay. So the case has already been nollied here, so the state can take it to the grand jury.
I don't think it's been nollied here yet.
I have a judgment entry.
When was it nollied?
June 12th.
Well, that can't be right. We've come to court multiple times since then.
There's another case, the theft violation.
Yeah, there is a misdemeanor.
Oh, okay, I gotcha. I see what you're saying. Yeah, that makes sense now.
So are those out?
They're the same incident, Your Honor. So if the state intends to take this to the grand jury, that would need to be a nollie on the theft.
It's a Walmart theft. Or nollie it also?
Yes, Your Honor.
Okay, 23-321 is also nollied, so both of these will go to the grand jury now.
Thank you, Your Honor.
Thank you.
You're welcome.
But just procedurally wise, would that just be nollied outright since the other one was already nollied? It's not like we're nolling that to the grand jury?
There's really no distinction.
Academic, there's really, yeah, it doesn't matter if it's nollied.
To your records, maybe.
There it is for the Supreme Court.
Oh, okay.
They're taking it to the grand jury, so.
But out of this court, it would just be dismissed outright.
Well, it's not dismissed, it's nollied. There is a difference between a dismissal and a nollie. Because a nollie can be refiled.
Well, for Supreme Court, I mean, that there is,
Yeah.
I'll just do it nollie to the grand jury.
Nollie to the grand jury, that's where it's gonna go.
And I apologize, Your Honor, because I was working on something else when there was an explanation of why she didn't want to go to treatment.
I don't think there was an explanation.
Nobody's let me talk, actually.
Well, in court, it's better if you don't, because what you say can be used against you. And one of the charges you're facing is a drug charge, so if you get in here and start taking statements that involve drugs, it could potentially be used against you. But if you want to speak, you're an adult, you can make that decision, but as your lawyer, part of my job is to tell you that's a bad idea. At this point, the case is going on to the grand jury, nothing you say here is going to help you.
Okay.
So it's better just to...
I am inquiring, and I understand Mr. Steyer, and I think his advice is sound. But before we send this to the grand jury, this just doesn't seem like something that needs to. And maybe I'm wrong. Maybe she has a defense. I don't want to know. Maybe Mr. Steyer can talk with her. But what we want to do is do treatment.
Basically, she doesn't feel she has the time due to other commitments to undertake inpatient treatment. If this, but where this has already been nollied, normally what I would say is, can we keep the case here, follow her through treatment, and perhaps the judge would approve her not doing inpatient treatment. My understanding is she hasn't actually been assessed by anybody as needing inpatient treatment yet. I don't think there's been an assessment done that actually says, yes, you need to go inpatient. She had an assessment done by OVP that did not indicate inpatient treatment, but it's my understanding, but I don't have that here today.
There's facts in it right now, actually.
Well, okay.
But anyway.
But I don't have it in my hand at the moment.
Right.
But if she hasn't actually been, if she hasn't been assessed as needing inpatient treatment, I think it's kind of dodgy to make her participation in the program dependent on something that hasn't been recommended by a licensed assessor, but.
When she was here Monday, Your Honor, she was sent to OVP, but I don't think that she was actually assessed for AOD.
I was. That's what they're faxing over. I was assessed for that, but they also assessed me as being bipolar, which I had never been diagnosed for before, and started me on a bipolar medicine.
Well, the problem here is that this case the felony was dismissed to QRT a long time ago, and she was complied with what they wanted, with the understanding it would go to the grand jury if she was non-compliant. They're saying she's non-compliant. The case is already gone from here.
Well,
the only thing still here was the misdemeanor.
If the state wished to keep the matter here, I would not object to them refiling the felony here, which I think they can do, and then they can begin later knowledge of the grand jury if they wish to.
So maybe we've gotten the cart before the horse a little bit. I think we would like to see what OVP says that she needs, and then let her make a decision based on that.
I'd like a minute she said that she had OVP send that to my email, and I have that email with me.
Okay.
And they're
faxing it to the
supposed to
court.
fax it to the clerk's office.
To the court.
And there's a pending misdemeanor charge.
There is.
And that is a theft charge.
Well, 2 minutes ago. Well, it hasn't been signed yet. I haven't signed
It's
it.
not pending again.
All right. So we'd want to try to resolve that as quickly as possible. I don't know how she feels.
Why don't we take a break, let you all
What?
look at the,
Yeah, let's
talk about it, and then, what else do we have? One more case, and then I can hang around as long as we need.
Right, thank you. Hang tight. I think I'm in the next case too.
State of Ohio versus Andrew Curry, case number CRA 23464, ABC, CRB 23463, CRB 23291, CRB 23361, CRB 22351.
I don't know if we have him brought out.
Yeah.
Andrew Curry.
All right, so this one. Never mind. I know this name, but I don't know where we stand on everything.
There is
Something happened last night, right?
Yes, sir.
There's some old cases pending, or that are on review. There are 2 new cases. One's possession, one is a
Open dumping.
Open dumping.
Oh, that guy.
Yeah.
This guy with the dog at I put the order on, is taking a vacation at the animal shelter while he's in treatment.
Okay, and Your Honor, I'm not completely certain what the details of the incident last night, but I think that it has led to the situation where it's Riverside, was not Riverside, RRS, not PPR or ARC, or ARK, I'm not sure.
RRC, RRS, RRG.
RRS is no longer interested in providing treatment to Mr. Curry. Mr. Curry expressed to me that he was interested in going back into the program, so Mr. Gwynn, I can't take you back. So Mr. Gwynn has made inquiry and has found another program that can take Mr. Curry. I can't remember who that is.
Shawnee Counseling Center can take him. The problem is they don't have nobody to transport him until Tuesday.
So,
Counseling Center? The Counseling Center or Shawnee?
Shawnee Counseling. Shawnee Counseling.
I'm
That's the new one.
going to
Well, that's going to get confusing. There's already a Shawnee Counseling. Is it the same?
I can't make them take you. If they don't want to take you, I can't say, oh, you have to take me. That's, I don't know what happened, but they don't want you anymore. It's basically, and I saw, I was there last night. I saw him, prayed with him, with Pastor Mike and his fiance.
Well, I mean, the issue is not, I don't think the issue is that they can't take you until Tuesday. The issue is they don't want to come get you until Tuesday. So if the court were inclined to allow him out, he would, which, are you still game on, Ron? Okay, that's right, okay. If the court were to allow him out, he could self-report, I would assume prior to Tuesday, couldn't he? Because my understanding is the whole of his transportation, not availability of.
I would like to know what the problem was, why he's being kicked out. I think it's important.
Okay, so Your Honor, last night at the overdose awareness event, him and his fiance had been arguing. A counselor from Path Behavioral Health approached his fiance and started talking to him, and Mr. Curry decided to threaten the staff member from PACS.
And Mr. Curry denies that characterization of the events. But at this time, I'm going to suggest that we.
But no charges were filed.
No charges have been filed. I'm not sure how the report was made. So at this point, I think the best thing is just if the party can leave with RRS, they don't wish to provide services, and there's somebody else that will. I think that we can just bypass the whole issue, keep them on service, keep them getting services, keep them making progress.
That's what I want, people afford life.
So the question is whether the matter
very disappointing
here is one of bed availability or one of transport availability.
On the place, I can report to you, and on that day on Tuesday, I give you a chance to clean a little bit of my house like too. This is one of the court orders. This is right there.
And that is an issue that is before the court, isn't there? It's open dump that the state wants cleaned up. In that time frame, you can work on that.
I'm telling you, so give me that chance, man. At this point, I want the program, I need the help. I want the help. I'll go to another program.
Nope.
Okay?
My only choice is put you in jail
Wow, man.
until you can be transported. Nobody else has got a bed that could take Andrew today. I don't see anybody jumping up and saying, we want Andrew. We want him. No. We're going once, twice. Taylor?
What's going on?
He's not going back to RRS, so he needs a place to land.
Sure, why not?
Okay. So where are you released to Bethesda today?
If you don't mind, I'll call him on the weekend, I swear I will.
You need to get control of your temper. You don't need to say anything. Follow what your lawyer says. Just listen. Listen.
That's what it will be. Just let, good time to just be quiet.
Get control of your temper. Think before you talk. How are we gonna get him to Bethesda?
I actually have transport here right now waiting on
Okay.
We don't control money, that's all of the program. You know, you probably start probably, again, it's not.
But you got a felony. So, what is it? Let me give you a history lesson. You know what felony started out in Old English law? It meant you could be punished by death. All felony, no, just be quiet. Don't answer. Listen, look at me and listen, and don't talk back to me. All felonies were punishable by death. That's been changed. Now you know what it means? You can go to prison. If you get a felony, you get convicted, you can go to the state prison, not the county jail, prison. That's what you've got facing you. So if you mess up, you can go to prison. If you do this right, you're not only, well, I don't know that they're going to dismiss it, but you won't go to prison, that's for sure. That's really important. So you got to act like you care about that, but you're scared of going to prison. Are you scared of going to prison? Okay. I saw you there last night. I remember. We held hands and prayed, and then after that you get in an argument with her. Well, that's the allegation. Anyway, they are not coming in here very often saying we don't want somebody back in our...
Your Honor, you know I do not like to discharge clients.
So, not good. So, mind your P's and Q's. What did I tell you? Your temper. Keep your temper under control. Before you say anything, think about it. Because I don't think you do. And just think about what you're on the edge of going to prison. Adjust your behavior accordingly. You've done good as far as your treatment and being in recovery, but this is not a good
Seems to
thing.
get the best of him.
But you can recover from this, but you gotta do what they say when they tell you to do it, and don't backtalk, don't threaten people, don't get mad about stuff, or if you do, keep it to yourself.
Your Honor, we're already set for the 25th of September.
I think we need to come back soon.
Come back sooner than that.
Yeah.
Again, not available the 11th or the 20th, I'm sorry, the 11th or the
15th.
15th, okay, I was sitting here.
18th.
18th is available.
September the 18th. We'll see you then.
I'm assuming that is going to be in place of the 25th.
Yes.
Okay.
Changing from the 25th to the 18th, moving it up. Okay. You're on, you've had strike 2, so don't get strike 3.
I'm sorry, I just wanted to touch down.
So it's okay. Let's come in.
I didn't get a replacement, that's what we're looking for. I don't have a problem, but I've got a lot of problems, that's why I was taking the path for help me, I needed that help. Thank you. So I just think about my ankle up, and that was my father, and other issues I had, but that's what I'm needed for, I'm trying to go forward in my.
Okay. We're doing a reset. So I'm not going to look back at all that stuff. We're going to look forward, but no more glitches. Okay. All right. We'll see you on the 18th.
Can we get on the monitor for this?
Yeah. Bring him in.
I need to step out and speak to this.
Mr. Okay.
Who's coming in?
Corey Cordell.
Okay. I'll go out while that's going. What's this?
We need to do it.
Can you write this on?
We've already got one to the 25th, so this is earlier than that.
Oh, okay.
Where's my bailiff? I need my bailiff.
We're gonna get you an ankle monitor.
Corey Cordell file. You know, I don't know if it's already been taken out. Okay, Corey Cordell, I'll call back before the court. Who is his attorney?
Mr. Schmidt?
Roger still here?
Roger still here? I don't believe so. No.
I need to find out what happened to that
Okay, you're encountering some resistance.
I'm a little concerned.
I'm ordering him into custody. You're commanded into the hands of the sheriff. Yes, we'll address it on Tuesday. Have a nice weekend. I suspect you'll be more compliant on Tuesday. And you need to get behind him, ma'am, and support him.
I'm fully supportive of the recovery, yes, I am.
Okay, very good.
However it sounds.
Court's adjourned.
Your Honor, I think we may need to come back in on this.
Okay, right.
We're not ready to, but we will need to.
I'll be in my office.
Thank you.
Is it all good, is mine good to go, is he good to go?
I'm sorry, what?
Is Curry good to go? I mean, you don't need him anymore?
To the extent that I'm willing to work that, yes.
I'll get him.
I'll say.
So I'm gonna do it.
She doesn't really want any.
So now what? Yeah, she's saying that she did.
On that. This virus, which was very bad.
And that's right. I don't understand. In fact, what I was going to do is just have a trial with them.
Well, and she's coming.
Do we need her? Yeah, but here's the thing.
I'm texting her on my.
Okay, she can be a rebuttal witness.
We're still here.
They're supposedly
That's fine.
We're waiting.
And that's really not anyway, because it's like, yeah, it's actually just victim notes to me.
Yeah, that's fine.
Okay.
But you're saying that I have the file.
Do you want me? I didn't know what to do with this, is what I'm saying.
Well, you can give it to me.
Just as long as he don't get, and Strand don't look at it either, because it's got her work.
Are we having a jury trial on that?
Oh, it's right in it. No, it's not Strand, it's Thompson. Let me go find out somebody else. I need to find out what happened to this one.
And here's another one. I don't know what happened on this one either.
Oh, that's, yeah.
He
I think he
pled guilty,
pled.
tested positive. Okay, he pled guilty, so we don't have to worry.
I think that's the one they just took back there.
Lordy. All right, now, I want to tell you a couple of things. On Miss Devon Stapleton.
Oh, yeah.
I think the most efficient thing to do is to nolly the abduction charge so that we don't have a problem with court clinic. But I don't want Sarah Reed to think we're just dismissing it.
Well,